lawsuit.
Yes.
My lord, in a very compelling situation, my lord, I am bound to make a prayer before the lawsuits. In respect of item number 7, of course, it is an old matter, my lord, and I requested my learned friend of the other side, Mr. Roy, P.K. Roy. Of course, he has given the consent, my lord. My physical, I could not prepare, my lord. I am ill for last 3 days.
When do you want it?
May it be kindly listed in the next week, my lord,
Next week?
either on the 3rd or 5th of June.
Third. On third. Item 7. MD M.A. Raj Barbhuya,
Yes, ma'am.
learned counsel for the appellant with consent from the other side,
Mr. P.K. Roy,
submits
senior
that
counsel.
due to some compelling circumstances and don't say submits, seeks seeks adjournment due to compelling circumstances. Prayer is allowed. Relist on 3rd June.
Can it be on
Much obliged.
my lord, fifth, my
All
lord?
right. Yes.
Deeply obliged.
Much obliged.
Lordship, item number 8, my lord. With the consent of the other side, let me post it after 1.
You wait.
My lord, I have
appeared. I have appeared.
You wait.
some personal difficulties, my lord.
Wait. Let's see.
Lord.
Yes. Do not make any more mentions of the old matters. We'll see when the matter is called.
May I please, Your Lordship? Your Lordship, with the consent of the other side, I beg to mention item number 11.
Yes. What do you want in 11?
I pay for adjournment for today, Lordship.
Why?
Lordship, having a personal difficulty, we have, as part of convenience, we have come to a date, Lordship.
You have?
Any other date, please. A
Yeah.
convenient date will be Lordship 19th or 6th June, Lordship.
Mr.
S.A. Bhakhtiar.
No, the appellant is who is appellant?
Appellate.
I'm for the appellate, my lord.
Mr. N. Hoffman, learned counsel for the appellant and Mr.
S.A. Bhakhtiar.
So and so jointly seeks posting of this matter on any date next week.
19th of June, Lordship.
Seeks accommodation for the day. Prayer is allowed. Relist on 19 June.
That is much obliged.
May it please your lordship, with regards to item number 10, lordship. Lordship, only for today accommodation may be required, lordship.
Wait. Yes.
My lord, I'm for the respondent, my lord. I'm for the respondent.
Wait.
Yes, yes.
Yes.
My lordship, with consent of other side, I would like to mention item number 5.
5 is an old matter.
All matter.
It's a part-heard matter also.
Yes, senior counsel R.C. Bharpatra could not come because he is ill today.
Whose will?
Dr. R.C. Bharpatra Gohai, senior counsel, he is appearing in this case.
He told me day before yesterday, but he's not keeping well. That's what.
The 2012 matter.
Well matter, my lord.
Part-heard before this bench. When can we have it? Monday?
19th June is.
No, 19th is too far. Monday.
Okay.
Second.
On second?
Second.
Yes.
Mr. Your name?
S. Ahmed.
Mr. S. Ahmed, learned counsel, appearing on behalf of the petitioner, submits that Mr. S. Bharpatra Gohai,
R.C. Bharpatra.
R.C. Bharpatra Gohai, learned counsel, learned arguing counsel on behalf of the petitioner is indisposed today and accordingly seeks a short accommodation. Mr. T.C. Chutia, learned additional senior government advocate for the state, does not oppose to the said prayer. Relist Monday date to deliver on second.
Obliged.
Yes, call the list, please.
Please, lordship. My lord, in this case, my lord, the learned trial court, my lord, dismissed the, my lord, I told so long I was the defendant, lordship. My lord, dismissed on the ground that the plaintiff failed to, my lord, prove the case, my lord, only on the basis of Sita.
Today is for framing substantial question.
Yes, lordship. In additional affidavit, lordship, I have framed substantial question of law, lordship.
Why you had to file an additional affidavit in the original application? You did not.
It was there some technical problem. some technical problem of that is why.
Where are the substantial questions?
My lord, number two lordship,
Number,
substantial question of number two lordship, 2 and 3 lordship,
page,
page 83.
page 83.
Roman 2 lordship. Substantial lordship, Mary.
Yes.
Substantial question of law arises as to whether the findings of the learned first appellate court declaring the right title and interest of the respondents is justified merely on the basis of purported draft CETA, that too having no mention about the source of making such entry therein, or in absence of any documents of their title. The annual patta purportedly issued by any authority with respect to the sought land is required under section 101 of the evidence as settled position of law is that draft CETA is not a title of property. Now, my lord, on the first appellate court, my lord, has reversed the, my lord, decree lordship on the basis of lordship documents, no title of documents having no title lordship. The annual patta, my lord, their claim was that their ancestor, their my lord, father has had, my lord, been allotted with, my lord, the land, but that allotment order was not exhibited lordship.
But that,
Only on the basis of CETA.
then the appellate court has, is a factual court. The first appellate court is a factual court.
Yes.
The court has seen that the trial court, before the trial court, there was no evidence.
My lord, documents, my lord, question of law is that whether in absence of title lordship.
Where is the first appellate court's order?
Yes, lordship, first appellate court order lordship. My lord, at page 53, lordship.
53.
Yes, lordship.
Yes.
Now, my lord, issue number C and D, lordship. At page 72. Lordship, page 72, lordship.
Yes.
My lord, starts from, my lord, paragraph 2, lordship, my lord, paragraph 2, from exhibit 1, lordship. From exhibit 1, it appears that there is 3 bighas 10 lesses of land under that number 264 in the name of Babar Ali, Borhan Ali, Sahib Ali, Hazrat Ali, Abdul Mannan, Moinuddin and Bilal Hussain. As per exhibit 2, there is 3 bigha 4 kathas of land under that number 265 standing in the name of Darog Ali Mia. Well, this 265 is not, my lord, in this court, lordship. Now, paragraph
We are
13.
concerned with this dark number 264.
Yes, lordship. My lord, paragraph 13. These citas reflect the names of Babar Ali, Borhan Ali,
You are?
defendant, lordship.
Yes, please.
My lord, these citas reflect the names of Babar Ali, Borhan Ali, son of so-and-so, Darog Ali, Sahib Ali, Hazrat Ali, son of Ghulam Ali, Abdul Mannan, son of Moinuddin,
These are the petitioners. These are the petitioners. The plaintiffs.
plaintiffs, lordship. My lord, only on the basis of CETA, lordship.
All right. You see, I have to understand the facts.
Yes, lordship.
So that is,
Yes.
why are you getting anxious? Yes, read.
Yes.
Settle law.
This CETA, lordship. The settled law in respect of CETA is that it is based on possession. As apparent, the suit land is annual patta and it reflects names of the plaintiffs. This means that annual patta has continued in their names and has not been cancelled by the appropriate authority. Nowhere in the CETA there is entry of name of defendant or his father about oral purchase or sale or delivery of possession of the suit land 3 bighas 10 lesses 25 years ago. In the evidence of record of PWs, what is formed is that suit land is annual patta. It belongs to Darog Ali. Earlier and after his death, his 2 brothers are possessing the land. It is admitted by PWs that there is house of defendant on the suit land And on 11/9/2017, there were attempts to dispossess. My lord, this is most important. There were attempt to dispossess the defendant from the disputed land by Hazrat Ali. Bilal Hussain, Sadhu Mia, Surahab Ali, Hassan Ali, and Mannaf Ali. It is also in the evidence on record that since 2017, plaintiffs possessed this disputed suit land for plowing. There is house of Nasiruddin within the 3 bighas 10 less. Nasiruddin, my lord, defendant lordship, the appellant lordship. 3 bighas 10 less land. PW5, the official witness have approved that Exhibit 1, 2, 3, 4, and 6 have exact resemblance to Sita book and that it was issued from their office. On the other hand, PWs in their evidence admits that pattadar of land under the number 264 are the plaintiffs, Borhan Ali, Babur Ali, Moinuddin, and his legal heirs. The land is not meted in the name of the dependent. Land revenue is also paid by the plaintiff. The suit land 3 bighas 10 lessas was purchased by the father of the defendant by Katsas sell deed, where the witness is not known. For how much money the suit land was purchased is not known. The Katsa deed is not submitted. Therefore, from the above evidence on record, it is clear that the suit patta land 3 bighas 10 lessas is in the name of plaintiffs. They are paying land revenue since 2017. Land is under their possession. Defendant has failed to prove sale and purchase of land 3 bighas 10 lessas from their plaintiffs and have also admitted that the amount of consideration is not known. Witnesses of Katsa deed are also not known, and even defendant are not mutated over suit land in the SITA, and name of plaintiffs are continuing till today. Both the orders of the Honorable Criminal Court and Additional Deputy Commissioner have found defendant to be in possession. My lord, 144 proceeding was their lordship. In that proceeding, my lord,
You were found to be in
yes,
possession.
lordship. However, possession of the defendants based on the materials on record is not found to be a legitimate possession backed by proper documents. Hence, the defendant must be held to be a permissive possessor from 2014 to 2017. It is also on record that since 2017, plaintiffs are in possession land that is possessing the land that is 11/9/2017. As such, defendant is liable to be evicted from the portion of land which is under his illegal possession, having failed to prove title to the suit property by valid registered sale deed. It is also in the evidence on record that the disputed suit land is of that number 264, measuring 3 bighas 10 lessas. Other two ducts.
All right, I
65.
think
Well,
that-
these are not concerned with.
Not really.
Now, my lord, the plaintiffs to establish their case lordship to have declaration right title of interest lordship, they have proved their title lordship, not the witness, not the point towards the my lord defendant's lordship.
How the second appellate court will go into all that, Mr.
My lord, that is the
Counsel?
question of law lordship. My lord, the Honorable Supreme, kindly see the findings of the learned first my trial court lordship. Paragraph 7, yes.
The trial, the
Paragraph
first
39.
appellate court has re-examined the facts
Yes,
and after appreciating and reappreciating has found that you could not prove your possession, you had only possession.
Yes.
You had no other title to the land and you have been in possession only for a brief period, 2014 to 2007. After 2017, it is the plaintiffs who were in possession, and that apart, the plaintiffs' title, everything, the appellate court has held. They have it.
my
Now,
lord,
how
findings
this
of the
court-
learned, yes.
You see, you have to convince me on how. Now, because unless there is a question of substantial, you see,
Yes,
there could be a question of law, but question of law is not substantial question of law, right?
Lordship.
Now, you have to ultimately you have to convince that there exists a substantial question of law.
Yes.
It is only then I can frame it, right?
My lord, kindly see page 39.
What is troubling me, I am being vocal so that you know what is to be, what you have to say in order to convince this court. Only for that reason I'm being vocal. See,
My
it
lord,
is very clear from reading. I have not read the trial court's judgment. Maybe we will read that also now. But from the appellate court, what appears is that the appellate court, after reappreciating the facts, because it is the appellate court who is the final court on facts, correct?
yes,
Not this court. It is the appellate court. Now, the appellate court says that plaintiff has the title, number one. Number two, after 17, it is the plaintiff who is in possession. As far as you are concerned, you only had possession from 14 to 17. These are the factual parts. Now, if you show that the plaintiff has no possession, that is different. But first and foremost, you have to assert that you have a right.
no lordship,
A right.
no lordship. The first, my lord, burden is the, my lord,
No, but
Plaintiff.
your possession
My
was
lord-
only till 17.
my lord,
Not
first
after
burden
that.
submitting lordship. First burden is upon the plaintiff. He has to establish case, my lord. Thereafter, my lord, burden
Are you
chief.
carrying any
My lord.
authority?
There is, now, whether
Are you
question
carrying
is,
any authority?
yes, lordship,
So-
I am coming to that. Now kindly see lordship, page 38 for a moment, lordship.
Page 38.
Yes, lordship. My lord, this is the judgment of the, my lord,
Trial
learned-
court.
right? Yes, lordship. Page 38 starts from point, my lord, paragraph 21. 38. Lordship.
Yes.
Defendant assailed Exhibit 1 on the basis of the cross-examination of PW5 Nihar Khan, wherein he had revealed that the source and date from which the names of Borhan Ali, Saheb Ali, Abdul Mannan and Moinuddin were mutated is not mentioned in the SITA book corresponding to that number 264. Then again,
One sec.
my lord, paragraph 38, paragraph,
One sec.
sorry, lordship. Paragraph 21, lord. Respondent number 5 is the Latmondal. His evidence that the how, from which source it was mutated, it is not known. My lord, then my lord, the plea of the plaintiff that it was my ancestral property and land was, my lord, allotted to his name. After his death, my lord, land was, my lord, mutated in our name, lordship. It was not there, my lord. Now my lord, allotment order was not exhibited. Only SITA copy, my lord. The only SITA copy was exhibited. On that basis, lordship. Finally, see, like, trial court judgment is very much clear, lordship. Now,
Paragraph.
my lord, paragraph 21. My lord, page 38. Defendant assailed Exhibit 1. What it, lordship?
Page 30.
38. 38.
No, page 38 is 21.
My
Para
lord, page-
21 you have already
Paragraph
read.
21, lordship. Already did.
That we have read.
Now, my lord, paragraph 22.
Yes.
Now, a SITA entry only indicates that a party was in possession of a certain plot of land at the time of survey. It does not confer any title over any land. In our case, the plaintiff's claim is that the entries in the SITA book in their favor have been made on strength of the annual patta allotted to them, but they did not produce the annual patta itself as evidence. This is very important. Title, annual patta is the title, lordship. Document of title. That was not exhibited. Further, there is no note in Exhibit 1, 2, and 3, the SITAs, indicating that the entries in therein were made in pursuance of allotment of annual patta in favor of the plaintiffs. That should be, source should be indicated, lordship, and their evidence, my lord. Their witness PW5 stated that there is no source mention about the source of, my lord, mutation, lordship. From whose connection it was mutated, lordship. As already mentioned above, the plaintiffs had argued that as the defendant has not denied the title of the plaintiff, as such the question of right, title and interest ought to decide in their favor, relying on the principle of preponderance of probability. But in my considered opinion, this admission by the defendant does not absolve the plaintiff of his burden to at least prima facie prove his title over the suit land. In this context, it is pertinent to refer to Section 103 of the Evidence Act, which provides that the burden of proof as to any particular fact lies on that person who wishes the court to believe in its existence unless it is proved by any law that the proof of that fact shall lie on any particular person. Adverting to our case, plaintiffs have only able to prove the fact that they were in possession of Schedule A, B, and C lands at the time of survey. The plaintiffs have not been able to establish their claim that they had acquired right title and interest over the Schedule A, B, and C on the strength of the annual pattas allotted to their favor. Now the Honorable Supreme Court.
Yes. But this names in the chitta has not been cancelled till date. It still stands in the name of the plaintiff.
My lord, that is, what is the, my lord,
No.
chitta lordship? That is, my lord.
See, I have no difficulty understanding
Yes.
what rights of record means.
Yes,
Please answer the query that the court is asking. The names of the plaintiff still exist. in
that
the
is not
chitta?
cancelled lordship.
That has not been
It's
cancelled.
not cancelled,
Very well.
my lord. Now question, my lord. It is a first of all lordship, Union of India in 2000 Union of India and others versus Varsovie, my lord. Varsovie Cooperative Housing Society, my lord, paragraph 14, kindly see lordship.
What was the, where is the plaint? What is the prayer sought in the plaint?
Plaint lordship. Lordship, plaint is at page. Lordship 8.
Page 8.
Yes, Lord.
Prayer is at page,
My prayer is at page lordship 15. Well, I'm sorry, yes. My lord, 14 lordship,
page 14.
page 49. My lord, first here, decree be first,
Yes.
decree be first for a declaration the right, title and interest upon the respective part of the plaintiffs within the D scheduled land. Decree for declaration the right, title and interest of the plaintiffs upon the A scheduled land. Decree for a declaration that the defendant has no any manner of right, title and interest upon A scheduled land or upon A1 scheduled land within A scheduled land. Decree for a declaration that the defendant possessed A scheduled land to cultivate upon it as the permissive possessor over the plaintiffs for a period of.
Where is the appellate court decree?
My lord, appellate court decree is lordship at page 79. Page 79.
Yes.
The plaintiff paid the the title appeal number so and so from the judgment and decree of the Court of Civil Judge, Senior Division number 2, Barbeta dated so and so in connection with the this appeal coming on or for hearing on 29/10/2024 before Srimati so and so. Is as well for him, learned advocate so and so. These are advocates name. Next paragraph, order. It is ordered that the appeal of the appellant plaintiff is allowed partly with the following relief. The suit of the plaintiff is decreed partly declaring the right, title, interest of plaintiff upon a scheduled land, declaring that the defendant.
Scheduled land is the 264, that
Yes,
number.
boss. Declaring that the defendant has no manner of right, title upon the scheduled land or a scheduled land. It is also hereby declared that the defendant was a trespasser over a one scheduled land and he is liable to be evicted by removing structures therefrom and to deliver cast possession of a one scheduled land to the plaintiff. Permanent injunction is also granted to the plaintiff restraining defendant to enter into a scheduled land from causing any obstruction or disturbance in the peaceful possession of the plaintiff over a scheduled land after eviction. Cost of the suit is also decreed in favor of the plaintiff. Now, first, my lord, the prayer is, my lord, for a right title interest lordship. My lord, the plaintiff, my lord, in my humble submission, lordship, the plaintiff has to establish their right title
Understood,
interest.
understood. Let's read that apex court decision.
My lord,
Let's
decision,
see the
lord-
facts, the Union of India case, Vasavi Corporate.
yes, lordship, that is
Come to
paragraph,
paragraph 2. Let's see the facts first.
yes, lordship. Paragraph 2, lordship. The plaintiff's case is that it had purchased the land situated in survey number so and so from villas from the so and so partner and his sons and others during the year 1981-82. This woodland in question forms part of survey number 60 and 61. This land in question belongs to the family of the Venkata Narasimha Reddy, consisting of himself and his sons Anna Reddy, B.V. Pulla Reddy and B.M. Rama Reddy and Anna Reddy's son Prakash Reddy. Land in the old survey number so and so was allotted to Rama Reddy, white registered family settlement and partition deed numbers so and so. In the subsequent resettlement of villas so and so, the land in survey number so and so was renumbered as survey number so and so 61 and 60. Ever since the allotment in the family partition of the above mentioned land, white the family partition on deed number so and so, Rama Reddy had been in exclusive possession and enjoyment and was paying land revenue. Rama Reddy's name was also mediated in the Pahanis. Plaintiffs further stated that the first defendant had in its AOC center building complex in Chimagiri village adjoining the suit land survey number so and so of Kakagura village. The first defendant had also requisitioned 4 acres and 28 guntas in survey number so and so of Kakaguda village in the year 1971, along with the adjoining land in Malagiri from extension of AOC Center. Further, it was stated that 6th December, sixth defendant took possession of the above mentioned land and delivered possession of the same to other defendants. The third defendant letter, by his letter number dated so and so, sent a requisition for the acquisition of 4.38 guntas in survey number so and so for the extension of AOC Center. Notification was published in the official gazette dated so and so, and a declaration was made on so and so. Compensation was awarded to Rama Reddy, by number awarded dated so and so. The plaintiffs, as already stated, had entered into various sale deed with Rama Reddy during the year 1981-82, by which land measuring 13 acres and 8 gunas in survey number so and so acres and 04 guntas in survey number so and so acres and 20 guntas in survey number 62 were purchased. That is, in all 41 acres and 32 guntas. Plaintiffs further stated that the land which was purchased by it was vacant, but persons of the defense department started making some marking on the portions of the land purchased by the plaintiff, stating that a substantial portion of the land purchased by the plaintiff in survey number so and so belongs to the defense department and treated as B4 in their records. Plaintiffs then prepared an application dated so and so to the district collector under AP Survey and Boundaries Act for demarcation of the boundaries. Following that, Deputy Director Survey issued a notice dated so and so calling upon the plaintiffs and third defendant to attend to the demarcation on 25/1/84. Later, a joint survey was conducted. The third defendant stated that land to the extent of 4 acres and 3 guntas in survey numbers so and so 60 and 61 corresponds to their GLR, general land register number so and so, and it is their land as per record. The deputy director of survey, however, stated that lands in survey number 60 and 61 of so and so villas are patta land as per the settlement records and vacant, abutting so and so villas boundaries to military pillars and not partly covered in survey number 60. Plaintiff later filed an application for issuing of certificate as per the plan prepared by the revenue records under section 19B of the Urban Land Ceiling Act. Plaintiff further stated pending that the application officers of so and so engineers on the direction of third defendant illegally occupied land measuring 2 acres and 29 guntas in survey number so and so acres 01 guntas in survey number 61. Thus, a total extent of land 6 acres and 30 guntas was encroached upon and construction was effected despite the protest by the plaintiff. And under such circumstances, the plaintiffs prepared the present suit, these details of which have already been stated earlier. Now, paragraph 12, my lord,
I have read. Continue.
yes. The third defendant filed a written statement stating that an area of land measuring 7 acres and 51 guntas out of survey number 160 and 61 of Kakagura village comprising GLR survey number so and so of cantonment belongs to the first defendant, which is locally managed and possessed by defendant number 3 into local representative of defendant number 1 and D3 and is also custodian of all defense records. Further, it was also stated as per the GLR, the said land was classified as P4 and placed under the management of defense estates officer. It was also stated that the suit land is part of review survey numbers 60 and 61, and the plaintiff is wrongly claiming that the suit land was purchased by it. Further, it was also stated that the plaintiff is threatening to encroach upon another 6 guntas of land alleged to be situated in survey number so and so. It has also been categorically stated that as per the records maintained by third defendant, land measuring 7 acres and 51 guntas forming part of GLR survey number so the commandant is part of survey number 160 and 61 of village. It is also possessed and enjoyed by defendant number 1 to 4 and 7. The plaintiff, in order to establish its claim, examined PWC 1 to 4 and produced exhibit 1A to 1A85 and exhibits 1 to X1 to X10. Besides exhibits A86 to 89 on behalf of DW1. On behalf of defendant DW1 was examined and exhibit D1 and D2 are produced. The primary issue which came up for consideration before the trial court was whether the plaintiff has got ownership and possession over 6 acres and 30 guntas covered by survey number so and 61 of villas villas for which consideration reliance was placed on the settlement record set or exhibit A3 of 1353 firstly. On the other hand, the defendants placed considerable reliance on GLR survey number so and so, which is part of survey number 160-61 of Palgasia village, Kaga Guda village, wherein according to the defendants, the suit land falls. PW2, this deputy inspector of survey stated according to Satwar, land in survey number so and so is patta land of Prakash Reddy and others, and such survey numbers corresponds to old survey numbers. The evidence of PW3 and 4 also states that the land is covered by old survey number 53, which figures in survey numbers 60, 61, and 62. Exhibit A3 Satar is a settlement register prepared by the survey officer at the time of revised survey and settlement in the year 1958. Firstly, in which the names of the predecessors in title of the plaintiffs are shown as pattadars. In other words, exhibit A3 is the exhibit of rights and title of plaintiff's predecessor in title. Defendants, as already indicated, on the other hand, pleaded that the total extent of survey number 53 was only 33 acres and 12 guntas, and if that be so, after subdivision, the extent of subdivided survey numbers would also remain the same, but the extent of subdivided survey numbers 60, 61, and 62 were increased to 41 acres and 32 guntas in revenue records without any notice to the defendants, which according to the defendants was fraudulently done by one Venkata Narasimha Reddy, the original landowner of survey number 53 of Kakaguda village, who himself was the
All right, that case I have seen. Which is the other case? This one, Jagadish Prasad?
My lord, it is other case is lordship, Jagadish Prasad Patel versus my lord Shivnath and
On the
others.
same
lordship.
point,
My lord, 40, paragraph 40, 41, my lord, and the proposition of law is discussed here. lord.
para 40.
40, 41, lordship. Only 41, lordship, I'm sorry, lordship, 41, 42. 41, 40, last page, lordship.
Yes.
In the suit for declaration for title and possession, the plaintiff's respondents could succeed only on the basis, on the strength of their own title and not on the witness of the case of the defendant appellants. Lordship. Lordship God.
Yes, yes. 1 second.
My lord, may I read?
1 second. No need.
The burden is on the
Page 83. All right. Substantial question. 1 is okay.
my lord.
Then
2, my lord, 2 and 3, lordship. Also, my lord, necessary.
I think 1 and 2 is sufficient.
Lordship, yes,
No,
lordship,
isn't it?
yes. Yes.
Because as far as 4 is concerned, these are all part of it. Main is your 1.
Yes, 1 and 2 lordship.
In facts and law exceeded the jurisdiction and arrived into a wrong and perverse finding by misappropriation of fact and wrong. And
1 and 2 will do, lordship.
Heard Mr. M.H. Ahmed,
Lordship.
learned counsel for the appellant, stop. The second appeal is presented against where is the reference of the judgment and order of the first appellate court?
Lordship.
Okay, I got it. Against the judgment.
Judgment dated, lordship.
Judgment and order dated, judgment dated 6/11/2024 and decree dated 8/11/2024 passed in title appeal number 27 of 2023 by the learned civil judge in bracket senior division Borpeta, whereby the judgment and decree dated 3/8/2023, passed in title suit number 34/2019, passed by learned Munsif number 2 Borpeta, was dismissed. Was dismissed. Admit, issue notice, returnable 3 weeks, steps by registered post AD. Where you said appeal admitted. The appeal is admitted on the following substantial questions of law. Number one. Whether the findings of the learned first appellate court declaring the right, title, and interest of the plaintiff stroke respondents is justified merely on the basis of purported draft chita Stop, huh? The rest I am not saying because that is the factual thing which will be already there.
Loss,
That is your main case,
loss,
isn't it? That it is only based on the chita.
lordship, without my lord, title of
Number two, whether the finding declaring the possession of the plaintiff over the declaring whether the findings of the learned learned appellate first appellate court declaring the right, title, interest, and possession of the plaintiff over the suitland is perverse. Okay?
loss,
List after, on a call for the case records. List after 4 weeks on a date to be fixed by the registry.
my lord, application, my lord, for stay of,
Sorry?
my lord, application for interim,
Huh?
for stay of, my lord, execution loss. IA is there,
Aye.
lordship, tomorrow is the date for execution loss.
Execution is different. What execution?
My lord, this was a suit for declaration, my lord, declaration and eviction loss. So if,
You filed there.
my lord,
For the
tomorrow is the, my
execution?
lord, date lordship.
File it there.
My lord, I filed, my lord, here today, tomorrow, my lord, I filed objection, my lord, objection saying that the,
This I will not issue notice.
my lord, unless, my lord, unless it is state lordship, tomorrow, my lord, it will be executed lordship.
Next.
My lord, unless the, my state lordship, the lordship has already, my lord, admitted lordship.
You are not in possession, Mr.
My
Counsel.
lord, I am possession lordship. No, status quo, my lord, as,
No, no.
status quo as.
Nothing doing. Next. Call
My
the
lord.
next.
Item number 2. My lord, lordship on the interim prayer loss,
Next.
IA lordship,
Mr. Counsel, the next matter has been
Obliged.
called.
obliged.
Yes, Mr. Sharma?
May I please your lordship.
Yes.
Lordship, this
Is
is
the item two is for, why is it in orders today?
it is wrongly in orders, Lordship.
For admission hearing,
It's for disposal, Lordship, from Lordship.
Yes, what
Lordship.
is it? Some tender matter?
Yes, Lordship.
Yes.
Lordship, may please directly come to page 33.
Page?
33.
Yes, please.
This is Lordship tender dated 3/10/2023. In the top, Lordship will see the date.
Yes.
So this is e-tender invited so through a for annual job contract of dietary service, Lordship.
For
Lordship, the
what service? Directory.
dietary service in the Dibrugarh Assam Medical College.
Dietary, sir.
Dietary.
Yes.
So this is the first tender. Why I'm saying, Lordship, there is a history, Lordship. First, second, third, fourth, like that, Lordship. So this is the first tender.
Pleadings are complete.
Yes, yes.
Yes.
So it is the bid opening date, Lordship can see at Roman 5,
Yes,
is
26.
26/10/23.
Yes.
So Lordship, on that day, I'll go to that document, Lordship. I'll show Lordship will just keep the note, Lordship, the bid opening date is 26/10/23.
No, page.
It is the
Can you
first
just put
tender,
The page number, can you just tell me the page number?
page 33 itself, Lordship.
No,
In
no,
the
no. All right.
Page 33, Roman 5, Lordship,
Got it,
important
got
date.
it,
detail
got it.
10. Bid opening 26/10 at 11:30. Then Lordship may come to page 34.
Yes.
This is 16/11/23.
This is the second
Second. It is a retender, Lordship.
bid opening 11/12/23.
It is a, Lordship will take note, the e-tender, retender are invited. Lordship, the first line is said.
Retender.
It's
Yes.
a retender of this 310. So this is on 16/11/23.
Yes.
So Lordship is very correct. This is, Lordship can take it as a second tender.
Hmm.
And here in the Roman 5, Lordship can see
11,
bid
12.
opening 11/12/23.
Yes.
Now Lordship may come to page 35.
Yes.
Here again,
Retender.
it is a e-tender, retender. It is 9/1/24. Date, top.
These are for the same things.
Yes, Lordship. I'll show Lordship one by one. Lordship, it is unbelievable, but Lordship, this happens. Lordship. It is Roman 5, Lordship again.
9-2.
Yes. It is the third tender, Lordship.
Hmm.
Now, third tender reopening in the page 36, there is some corridendum that 9/1 they will not open. It will be held on 22/1.
2-1.
Then another
Finally, what happened? These were opened on the scheduled date or not?
in the last tender, they finally opened.
But otherwise, they were not opening. They issue the tender, they do not open and issue a
No,
retail.
all these tenders are open.
Open.
Technical, I'll show Lordship. The documents are there. The first tender is also open. Second tender is also open. Third tender is also open. I'll show Lordship why they are cancelling, Lordship. There is
Those reasons are there in their affidavit.
no affidavit. They have not filed any affidavit. They filed a short affidavit, Lordship. No reason, nothing. For all this cancellation, there is no reason,
Okay.
Lordship. So, Lordship, there is a
Mr. Gangwal is
corridendum.
very confident that this matter can be disposed of.
You have given the reason. Lordship. He
Yes.
is very correct, Lordship. Yes, file an affidavit, Lordship. Lordship definitely will, by the affidavit,
Yes, yes,
Lordship will
yes.
go. Lordship, at page 37, the second corridendum.
Yes.
So this is, again, the date is sent.
To 22-1.
Yes.
No, the date is changed to
It is in view of the half holiday on so-and-so, pre-bid meeting will be held
As a
Or
time, I
22.
think the same date time has been
At 2 p.m. Lordship.
Time to bolla is
At 2:30, at 2 p.m.
two
Lordship.
45
2:45 p.m. on
of 2 p.m.
Pre-bid meeting.
Yes.
It was a pre-bid.
All right. Then,
Now, Lordship, this is the third tender. Tender document is there, Lordship, at page 38. The whole tender document I have annexed.
page,
Page 38.
yes.
It is the third tender, whole tender document, Lordship.
Any changes between the?
No, it is the third tender, Lordship, what I have shown to you, Lordship.
All right.
Lordship, now please come to my paragraph 7 of the writ petition. At page 10. Then Lordship will come to know about the fact. Paragraph 7, page 10.
Yes.
That thereafter, for the third time, another notice inviting retender through the e-procurement system for providing annual job contract of dietary service to the patient admitted in Assam Medical College Hospital, Dibrugarh on 9/1/24 was issued by the respondent number 4 and 5. The same was published in the newspaper so-and-so. That aforesaid retender is of 2-bit system and the hard copy of the technical bit should be submitted to the Dropbox and the hard copy of the so-and-so. Then it is the bid opening date was fixed on 9/2. Earnest money is 10 lakhs. Tender fee is 6,000. The respondent number 4 and 5 issued a corridendum. Lordship, I have shown that to your Lordship on so-and-so date. Then the petitioner begs to state that the person to the tender petitioner paid the tender fee of so-and-so, also paid the earnest money and so-and-so. The financial bid was submitted online. The petitioner claimed leave of this unable to produce. Paragraph 11, Lordship. Important. It is the important. Now the Lordship will get the whole thing of the question of a Lordship. The answer is this, page 13. Page 13, para 11. That the petitioner begged to state that the technical bid of the bidders were open on 12/2/2024 and the petitioner was present. The tender committee presided by the chairperson in presence of 11 other members held tender bid opening meeting on 12/2/24 and evaluated the tender bid of the petitioner and the pro forma respondent number 7 and found both the bid technically qualified. Lordship.
Yes.
In the said meeting, it was resolved as under. After scrutiny of the bidders as stated above, we found it technically qualified as the tender was called for the third time. Lordship, it is their admission, Lordship. As the tender was called for the third time, the committee member has decided to open the financial bid on 20/2/2024 at 2 p.m.
What
Lordship,
does that mean?
Lordship,
What does that mean?
that the technical bid now they have opened, they will open the finance.
Under the terms and conditions of the third tender bid document,
Yes.
there must have been a scheduled date for opening of financial bid,
Yes. But
isn't it?
now they
Was
have
that on
decided,
the same date?
they have decided to open it on 22/24. Technical bid is open as per the tender.
But what is the procedure for financial bid?
Financial bid, they have given a date after the opening of the technical bid.
And that date is not 22/2024.
Yes, now it is 2020, they have given it. And now, Lordship, in the affidavit, though they have not given any document, Lordship, but they might.
Mr. Sharma, I'm just confused about
Lordship.
the opening. Generally, financial bids only qualified technical bid, they open the financial bid.
Yeah.
Now, in some tender, it may happen on the same day. Some may happen on a subsequent day because the evaluation of the technical bid takes time, right?
Yes.
Now, what was the criteria in this particular tender as regard opening of financial bid?
For technical bit.
It is technical bid is there. For the financial bid, it is not there in the tender document. Lord.
All right.
It is not there, Lord.
All right. So then they have decided that since since this is the third tender
Yes,
and they are all technically qualified, so they have opened it.
Technically qualified bidders, financial bid is open.
Correct.
yes,
Correct.
yes.
Criteria remains same.
No, I understand.
procedure remains.
Correct. I just wanted to know, because you see, every contract may have a specific clause. Generally, such clauses exist, right? So I just wanted to know factually in this particular contract, if a specific something is there. That's all right.
That lordship is page 38 is very clear. The technical bid opening is there, lordship,
Page
bid opening,
38.
page 38, annexer 8,
Yes,
Roman 5.
bid opening.
Bid
of-
opening is 9/2/24 at 1 PM.
Hmm.
It is they have opened it on 12/2
Okay.
because of that correlation.
Corrigendum.
Lordship. And lordship, the 12/2 they have opened the technical bid and they for opening the financial bid, they keep it for the 22.
Ultimately, it was given to R7.
No, not given lordship. Now lordship, though they have filed an affidavit, lordship may please come to the affidavit and the affidavit of
Your
the government.
challenge is what?
Challenge the lordship, they are cancelling all the time. Now third bid also, they have opened my financial bid, looking at that I am the lowest. Now they have gone for a jam tender.
Huh?
Jam tender.
Another tender.
Yeah, fourth time.
And after opening my financial bid, lordship.
Okay. What is that explanation?
No, nothing.
Because it is mandatory according to an office memorandum.
Yes, where do I-
Lordship, at page 97 is the affidavit.
No, that you are the lowest. Where is that?
I'll show lordship.
Page 97.
Lordship, at page 97, they are affidavit. They have not said anything in the affidavit, lordship.
97.
Page 97, lordship.
Yes. I think it starts at 97.
Page 97, lordship.
Yes.
This is their affidavit, lordship.
Yes, I think
It
relevant.
is filed by the respondent number
I think
4.
paragraph 499.
Yes.
Yes, lordship.
Yes, let's see paragraph 4.
Para 4.
Second part.
Second part.
Yes.
The department further beg to submit that only 2 bidders participated in the third bidding. In the first bid, tender bid, 3 bidders participated. However, in the second time, 4 bidders participated. In the third time, 2 bidders participated. Further, the government of Assam filed office memorandum dated so and so. Date is not there, lordship. Made it mandatory for JAM for all procuring entities for procurement of all goods and service that are available in JAM. Now, lordship, this notification they have annexed, though the date is not there in the signature, one date is there, it is 8/1/24.
8-1.
8/1/24.
And this date.
I'll show the notification. lordship.
The tender here is, the third tender date is?
It is the first tender, lordship, is started at page 33.
Just give me the dates. First tender,
First tender is 3/10/2023.
3-10,
2023.
2023. Second,
Second is 16/11/2023.
16-11-23, which is retender.
Retender.
Then,
Then again a retender
yes,
and 9/1/2024.
this is one day after
Yes,
the notification.
yes.
Then it's in 3/20.
So it is the 3. Now according to them, it is the notification they have given on 9/1 according to them, lordship. Though in the notification, in the affidavit, they have not said any date. But lordship, they have annexed one document where they have signed it on 8. Lordship, it is shown it is signed on 8, lordship. Because it is 9. My third tender is on 9th, lordship. So it is the 8th, lordship. Though it is the date is somehow, lordship, date is missing.
But the signature carries a date.
Yes, like.
Your records must be showing.
Well, lordship,
We have only the annex requirement. And
I am sure.
notification is of the finance department, not by the health.
yes,
No,
yes.
but.
So there is no question of south, my lord. It is.
No, only thing is the date has some relevance, right, Mr.
Yes.
Gogoi?
My lord, the signatory has given us this as 8-1 and it has been uploaded in the website also.
So
There.
it is
the
8-1.
the date.
8-1 is the date.
What is to be done?
Gazette notification, of course, there is doubt.
My lord, there is an act now.
There is a?
No gazette notification, lordship.
Not-
It is not gazetted, lordship. It is required, lordship. It is required, Lordship. I'll satisfy, Lordship. Lordship, my learned friend has said that date is there in the document. Lordship, may please come to page 105.
So he has not said that there is a date, but he said the signature has a date.
Yeah.
And it was uploaded.
That I'm saying, Lordship, in the signature, there is a date.
That is the admitted position.
Yes, that is an admitted. Page,
Anyway, in which page will I get?
page
this?
105.
Page 105.
Five.
Yes.
That page 105, ECF number so and so, dated nil, January 2024 loss in the top. Now,
Which part says this gem requirement?
A1. It is A1 loss,
Huh?
capital A1.
1.
Government e-market gem is mandatory for all procuring entities for procurement of all goods and services that are available in gem as per the rule 24.124 of the Assam Public Procurement Rule 2020.
But
And
this
Lordship,
is
it is
in
now,
terms of a statutory provision, it appears.
Lordship, they have given it,
It appears.
Lordship,
And the date is 8/1/24.
in the page 107, Lordship.
Just for an academic purpose, this what is instantly come to the mind of the court is that since this is a retender,
Yeah.
whether this
It will.
OM will have any
No, my.
bearing,
That's why.
because it's a retender, it's not
It's
a
a
fresh
retender.
tender.
Continuously, that is why I am reading this word
This
retender.
is one question perhaps
I'll satisfy your Lordship.
would
That-
arise.
Not
for
only that,
determination.
Lordship, there is no decision. The person concerned has not taken the decision,
Because
Lordship.
suppose the finding of the court that this is a fresh tender, not a e-tender, then of course, one view and
Yes.
perception would be because the tender date is 9,
Yes.
then they are bound to follow
The
the
8-1.
8/1 notification. That could be the
Because
cause.
it's
But
continuously.
suppose the finding of the court is, ki,
It is-
no, this is a
It is October
continuation,
23.
correct, 23. Then of course, by subsequent thing, you can't just because you're retendering.
And
it will
Lordship,
not-
no,
But
then
so therefore,
then Lordship,
that perhaps would be the most,
the answer is correct. Lordship, the page 107 last line. That is why the notification is correct. Notification not say that you go retrospective.
it's come immediate effect.
This cell came into force with immediate effect. So on that day, it has not given a retrospective lawsuit.
So therefore, the question is whether the third tender
It's
Is
a
a-
retender.
is undoubtedly the word used is retender, but whether that can be said to be a fresh tender or it's a continuation of the original
Yes,
tender which was issued
Yes.
in the month of October
yes,
2023.
yes, Lord.
I think, Mr. Gogoi, that is the legal question perhaps which is arising.
Of course, Lordship will raise that issue.
That is the issue.
Yes.
That is the only issue perhaps. Anyway, I'll
Because
come
the-
back to you. I don't want to
Because
disturb the
when-
flow of
when-
the senior counsel.
Moment the tender is cancelled.
Where is that cancellation?
That will place, for a civil place, in fact, I am sorry, it is there in the court record.
Mr.
So
Sharma,
Lordship, in the paragraph 8, paragraph 8 of the page 101,
yes,
because the filing of an affidavit, Lordship, it is not an empty formality, Lordship. It is the
Yes.
fountainhead of the whole judicial
Yes,
system, Lordship.
yes,
So let us see what is this affidavit, Lordship.
yes, because the deponent knows the facts, the court doesn't know. So
Lordship,
it is by way of affidavit that the facts can be placed before the court.
Lordship. And then after Mahendra Singh Gill, Lordship, by filing affidavit, they cannot develop. What is there in the record, they have to go by the record.
Yes,
So Lordship, let us read the paragraph 8, page 101.
yes, please.
That with regard to this statement made in paragraph 7 to 13, that I have read, Lordship, all those paragraphs. I have read from paragraph 7 to paragraph 13. The deponent has no comment to offer so far as a matter of record. So perhaps my learned friend will place the record for the purpose of this paragraph 7 to 13. Though I have not seen, Lordship. However, anything beyond the records are denied and disputed by the answering deponent. So it is denied that I have specifically said at page 14, para 12, that there is a minus that is 20 to 2024, that all those things they have denied, Lordship. The rest of the thing they have denied. Now, this affidavit is signed by the superintendent, respondent number 4, the principal cum chief superintendent at page 97.
Yes. In charge.
Trial court.
Hmm?
It's authorized.
He is authorized. All right. No, he is the man. He is the person. He is the R4 Lordship. And all the tender,
He's the issuing authority.
He's
Issuing
the
authority.
issuing authority.
yes, yes.
Yes.
So he has signed the affidavit, Lordship. Lordship, may please come to page 14 of my affidavit, of my writ petition,
Page?
page 14, para 12.
Yes.
Lordship, para 12, Lordship, get in?
That well.
Yes.
Sorry. Yes.
I specifically made a statement here, Lordship. The petitioner begs to state that the petitioner was present on 22/2024 as scheduled time for the financial bid opening. But he was informed that the financial bid would not open as few members of the committee were not present for the bid evaluation. Thereafter, the petitioner was been visiting the office of the respondent number 4 and 4, inquiring about the status of financial bid evaluation, but they informed the petitioner that due to absence of some committee members, nothing could be finalized, and when any decision would be taken, it will be uploaded in the aforesaid website. Does you get it? This is my specific paragraph in paragraph 12. They have not dealt this paragraph. They said the rest of the thing is denied, and they said it's a matter of record. And they said it is whether from the record they can show that this is uploaded or not. Now, what they do, Lordship, along with this affidavit, no document is filed, nothing. Now, Lordship, suddenly, when the matter was taken up, then on 9/4/2025, this court passed an order. 9/4/2025.
Yes.
Heard Mr. S. Sharma, Learned Counsel for so-and-so, Learned Counsel for order, B. Gogoi so-and-so, all this. The Learned Counsel for the petitioner, on the other hand, submit that he has instruction to submit, which has been also brought on record by way of a reply affidavit, that the steps for proceeding a fresh tender of JAM was pursuant to opening of the financial bid submitted by the petitioner in the third tender. This submission, however, been disputed by the Learned Counsel for the respondent. Now, accordingly, this court permit the respondent counsel to produce the relevant record before this court on the next date fixed to show as to whether the financial bid were open or seen by the respondent officer in the process of the third tender before calling for the fourth tender. Lordship, not only this, Lordship, in my writ petition, I have made a specific statement.
Para 15.
Lordship, at page 15, para 15.
Page?
Page 15, para 15. I made a specific statement, my lord, on instruction and on oath.
Yes.
That the petitioner come to know from a reliable source that 2 out of the 3 members, Lordship will read this. This is on oath, Lordship.
Yes, yes.
Petitioner come to know from a reliable source that 2 out of the 3 members of the tender committee surreptitiously opened the financial bid of the petitioner and the performer respondent number 7, and it was found that the petitioner is the lowest bidder. Due to some political pressure to accommodate contractor of their soil, the petitioner is being deprived from awarding the contract in spite he was being a valid lowest bidder, and with the evil design, the financial bid of the bidders were not evaluated by the tender committee, and in most illegal and arbitrary manner listed the work for fourth time through a JAM inviting fresh tender. Now let us see, if there's a specific statement made.
What the records you have produced? You have it.
No, Lordship, they have not put it, they have given some document to me on that day and before the court.
For the court, not to the petitioner.
Yes,
No,
yes.
no, what they have given also, Lordship.
What
In
is,
the open court, they have given that this is the, from the record.
Yeah.
Let us, yes, this is given.
what
yes.
is that? What is that?
Lordship, it is there, Lordship file. Lordship.
12 episode of.
I know my limitation, my lord.
But
That
it's,
Mr. Feld will not show the record to
it's
me.
all right. It's okay, Mr. Sharma. Mr. Gogoi, why don't you show me the records?
Well-
Where is that page? Because that page that you have given to Mr. Sharma must be a part of the record.
No, my lord, these are.
There's a date,
And there is
all
no
the
change and-
official notes
I
and everything
find
should
that-
be there in the record, Lordship.
I-
These are tender my lord record. There is no official note.
No,
Whatever
but,
proceeding is there, it will be in the
oh,
minute.
Mr. Gautam,
Then,
So,
did you? Just find out where that document is.
what's this one? So Lordship will take that bunch, Lordship, before I go to that bunch. Let us go to our writ petition, Lordship, because with this, I have given the document in the writ petition itself, Lordship, Annexure 12. Because whatever decision they took, they have to upload it, Lordship. It's an online thing. Once they take a decision, if it is not the backdated, then once they will take the decision, it is uploaded.
Yes,
Lordship, please come to page 65.
page 65.
Page 65, Annexure 12. It's still the opening of the technical bid.
Yes. Yes, yes.
Minutes of the third bid opening meeting held on 12 to 24 at 1 p.m. in the conference hall of the Assam Medical College Hospital, Dibrugarh, for providing annual job contract of the dietary service so-and-so in the tender dated 9/1/24. Lordship.
Yes.
So this is, all these persons were the member. Lordship will
This
take
is
note.
Bid opening meeting held on 12 to 20.
Yes, 12 to 24.
Yes,
Lordship, these are the member.
yes.
All these member, the person who have called for the tender is not there. The principal comes chief superintendent is not there.
R4 is not there.
Not there. Very correct, Lordship. Lordship, he is not there. They have not shown that he is not there. He is not correct, Lordship. No, Lordship. Lordship, may please.
The committee members opened the tender, both online and offline mode, and found two numbers of bidders.
Lordship, at page 66.
Yes, I'm reading.
Yes.
Yes. The committee scrutinized technical bid document of the above bidding. The details are so and so.
Then page 66. The committee member opened the tender both online and on so and so. Bidders were participating in the tender. The committee scrutinized the technical bid document of the above bidder.
As the
Details are
tender
which
was
is below.
called for third time, the committee members
page
have
68.
decided to open the financial bids on 22-24 at 2 p.m.
Yes. So this is 68. They have decided.
They have
It is decided, Lordship.
Now the question is, have they opened it or not?
Lordship, that's what.
Yes, decided to open on 22-2024. Then this decision was done on 12-2-2024.
To 2020.
Yes. So that is the decision.
12
Now-
to 24. 20 to 24. Yes.
Now,
Yes.
Lordship, this bunch, Lordship, come to page 11.
This is
Given by the-
Mr. Gogoi.
Yes,
Yes. Yes.
page 11. Minutes of the tender financial bid opening committee held on 20/2/2024. Lordship, get it, page 11.
Yes. This is the 22. Yes.
At 2 p.m. in the conference hall of so and so is the published
Since,
hide re-tender.
Huh?
Lordship, I'll read slowly. Minutes of the tender financial opening held on so and so in the conference hall of Assam Medical College Hospital, Dibrugarh, for providing annual job contract dietary service to the patient admitted in the Assam Medical College, Dibrugarh, published hide re-tender
Yes.
dated 9/1/24.
Yes.
Now, Lordship, these are the committee members where the respondent number 4 is not there. And he is the procuring authority. Lordship will keep in mind the word. Why I am saying, Lordship, they have referred to a section and all that the procuring authority, that section 24 in the finance department office memorandum, they have referred to a rule. So, Lordship will keep in mind that there is a procuring authority, entity. He is the authority who will procure, who has given the tender, uploaded the tender, the respondent number 4, and he has filed the affidavit. Now, Lordship, in this document, this person,
What do you want to show from that? That he is not a part of the the meeting. He was not present.
no. What I want to show, Lordship, now that is what I want to read. Lordship, may please come to page 11, down below.
Yes.
Down below, since there were only 2 bidders participating to the process, to have a better participation and involvement of more member of bidders to ensure the
Quality.
quality, the committee member would like to recommend, Lordship, get it, why I am showing repeatedly, Lordship. Now, this committee member, they have recommended it
R4.
to our. Today, principal comes so and so Dibrugarh to float a fresh tender through GEM portal. So now this document and in the affidavit, his decision is silent. And in the affidavit, Lordship, not only this document, the affidavit in the annexer, only thing is said that there is a finance department office memorandum, but this recommendation, his decision
All right. No.
is missing. So, in the affidavit, it is silent.
Okay.
I'll not read, but Lordship, I'll give this judgment, Lordship, first. Lordship, before I go to.
Blinders clip bhi apna. Yes.
First one to para 144.
Yes.
So my para 15, Lordship has read that. I have read the para 15 very clearly. And I make a statement there that I heard that open. Now in the affidavit, they are silent. Not a single word, Lordship. Even to my specific statement in the writ petition, they only said denied. They only said denied. Now, Lordship, may please come to.
One second.
Lordship.
This minute otherwise was not annexed in that affidavit. right?
No, no, no.
Only in the affidavit, there was also a mention about the two bidders participating, that part.
Yes,
That part is mentioned.
that part is mentioned.
According to you, there is a general denial, but there is no evasive denial or
Specific.
specific denial as regards the averment made by you under oath that the financial bid was opened on that scheduled date.
Or not even said that the financial bid is open. In their affidavit, they have to say, my lord, that we have opened the financial bid.
It's very sad that the affidavit is not happily worded. In not many, in not that many words, but they have said that two people have participated. GEM requirement is not there, therefore the decision, that's all. You know,
Yes.
very, and to, in support of that, now they have come up with this,
This
which,
document.
which shows that the
It was
committee
recommended.
had recommended.
It is recommended. Now, Lordship, every day, Lordship, this court is saying that they bring the original record and all that. And even on the last date, Lordship, when I.
Records, I'm told, is there.
Last date of the year, the order.
Why not make these affidavits? You just simply had to deny that averment. There is a how to deny, how to draft the affidavit. These are all there in the CPC also, isn't it? Strict CPC may not be applicable, but that is the principle. But that is the principle. You see, if you do not, this question otherwise has an important bearing. Now here it suggests that it may not have opened, but it doesn't say that bids were not opened. You see, that also it doesn't say,
Yes.
isn't it?
Regarding.
Now, you see why I am saying you this, because this matter may not just stop here, isn't it? But these are important issues because
Query has been raised, my lord.
Huh?
It is honorable court, in a
Huh?
subsequent order. This query, my lord, whether it was opened or not.
that query,
I have a written instruction, my lord. Since, my lord, this matter, my lord, hearing has started just now. So on my turn, my lord, definitely I will place everything, my lord.
if you have it, it is
I
all
will
right.
speak to them also, because
If you have it, it is all right,
the-
because you see, the query may be recent, but the petitioner has specifically pleaded in the writ petition that the financial bid was opened. So they have said it. The onus is on you to deny it and show that it is not open, right? Now this document indicates all that was required is one
My
sentence.
lord, it was open.
It was open.
Yes, that's why I'm saying, my lord, when my
Oh,
turn will.
then Lordship, may please come to page 102,
Okay, all right.
page 102.
All right, then I shall-
There is no.
I shall
have pending.
maintain, then I shall have some more patience. Sit.
Yes, sir. I will-
Page 102, Lordship.
102.
102, Lordship. Government affidavit.
Yes, 102.
Paragraph 10.
Yes.
Lordship query to the reply to the paragraph 15. Let us see what they have said. Paragraph 10, page 102. That with regard to the statement made in paragraph 15 of the writ petition, dependent beg to deny the averment made in the writ petitioner, specific lordship. What is my paragraph 15? I said two member has opened and I am the L1. And looking at that I am the L1, they have cancelled. That the opening of the financial bid and here, paragraph 10, they denied my writ petition averment
All right.
in the government affidavit. Now, Lordship, the court give me a liberty, this court, by order dated 8/5/2025, to bring on record the said document that due to the positive decision, in the meantime, the petitioner may file an additional affidavit that the financial bid is open. So we have filed an additional affidavit now. Let Lordship at page 143.
Yes,
Lordship get it. Para 4 at 144. 144.
yes,
That the petitioner on so and so date logged into the so and so website using the logged in credential. Thereafter, he found that two of the bid opener, namely, I have given the name also, Lordship. Hitendra Sonwal, Deputy Superintendent AMCH, and Soumendra Kumar Bhagavati, Deputy Superintendent AMCH, opened the financial bid and also used their decryption certificate to download the financial bid document. The petitioner instantly took a screenshot of the said web page. Therefore, it is apparent from the financial bid were opened as per the scheduled date and time that they were silent. And that document is at page 148.
yes,
Page 148. Lordship get it.
yes,
Page 148, Lordship can see on the top there was some bold line, Lordship, tender ID, tender title, Lordship get it.
yes.
Down below, bid opening, date and time.
2024.
Yes.
Yes,
Now, bid openers list, financial bid. This date was fixed for opening the financial bid.
yes,
Bid opener list, bid opener name, serial number 1, Hitendra Sonwal, designation, Deputy Superintendent, login status, log, then decrypt status, decrypted, non-decrypted, 1 person, this Partha Sarathi Borua has not
logged,
opened,
Not logged.
not logged. And this Deputy Superintendent, Soumendra Kumar Bhagavati, this 1 and 3 has opened. Now,
Today, Ranjit Purwa, financial bid open.
then down below, Lordship, active bids list.
Active bids list, yes.
Yes. 1, Ranjit Borua, bid submitted so and so,
Ranjit
packet
Borua-
contains.
Petition.
Ranjit Borua is the petitioner.
Okay. And excess contractor is
Private.
Axis is the response number 7, R7.
admitted status, opened.
Financial.
Packet content, financial bid status, admitted, comment, open. Now, there is a handbook, Lordship, that is at page 149.
Yes,
Handbook of the Assam State E-Procurement Portal,
yes,
that is Annexure 18.
yes.
There, Lordship, may please come to page 166. I do not know this e-procurement thing. I have to go slow, Lordship.
It's all right.
Bear with me, Lordship.
No problem.
Because we are learning this, Lordship.
It's all
now.
right.
This is earlier.
Every day we are learning. Yes,
166, serial number 2, financial bid opening. Lordship, see. The department user need to follow the following steps to open the financial document. There is a bullet point, Lordship.
yes.
Third bullet point from bottom.
Login to portal.
Third bullet point from bottom.
Yes,
As the financial bid document can be downloaded after at least 2 successful declarations, as in our case, Lordship, 2, minimum 2. Therefore, one more bid opener should decrypt the bid by using this same procedure. So if 2 open, then the others can see. Now, the second, after successful declaration, the 2 bid opener, a folder appear automatically. So the financial bid folder will open automatically. Click the board document, download all financial document in the zip format and so and so. So once we open, then you can look into it, you can download, you can do anything and everything else. That is their book, Lordship.
yes.
This shows the Malloc.
So my is that all these fact shows the malafide law. Not only arbitrary lawsuit, the arbitrariness is there. One first tender cancel, why? It is 2, then it is 4, again cancel, then they said we will go for more, then it is 3, cancel, now it is 2. Now lawsuit for all these 2, 3, 4, 1, the government department, some PWD department will do something, the health department will do something. So all this department, they are taking different stand. Sometimes PWD department say, no, one tenderer also it is all right. Health department says, no, it is only 2. No, we'll go for further. Jail will say, no, we'll go for only 1. We need the food early, so we'll go with 1 only, 1 tender. So what happened, lawsuit? Central Vigilance Commission has given some guideline for all the department because otherwise lawsuit, these departments, they are doing of their own. So the Central Vigilance Commission guideline, lawsuit is in my writ petition. Is at page 76.
Yes, CVC guidelines.
Yes. Then lordship may please come to page 87 because other things are not equipped for this.
Yes,
Page 87, 10.1. The tender evaluation and the award of work, lordship get
yes,
lordship 10.1. The bullet point number 5. Black dot, lordship. Ensuring that L1 is not ignored by flimsy ground. Lordship get it?
yes,
Then lordship, the same CVC, lordship may please come to page 94. It is the 15 January 2023, 2013. 15 January 2013.
yes,
There 3 is, as per the existing guideline of CBC, the single tender can only be accepted subject to recording detailed justification in support of acceptance and approval of the competent authority. Let's get it.
yes,
Then 95. C.
yes,
I'll skip the first 4 line, lordship. Second and subsequent invitation of bid tender. It is the third, fourth, lordship, not second even. I'll skip the first 4 line. The state may accept single tender in the second or subsequent invitation, lordship. Call keeping in view the guideline of the CBC in this regard. So mine was a third, lordship, and 2 tenderer. It is not 1, lordship. Lordship knows even if the 2 tenderer join, in the technical bid 1 tender go out, it is 2 tender. So they can go ahead. Here in the financial bid 2 tenderer is there. So there is no reason, nothing, lordship. All the whole process is arbitrary. The malafide is apparent, lordship. So now after all this, lordship, the lordship is very correct. Without going to all other thing, the lordship, the affidavit, lordship can see what they have said, what they have not mentioned, all this. And then my writ petition, no denial, nothing. Now, lordship, there is a direct decision on filing of an affidavit, lordship. I'll start with that, lordship, because then I will go to the law. Because I have to show that. It is 2014, 5 GLR, page 197.
2014,
2014, 5 GLR. Page 197. It is the Assam Company India Limited versus Bank of New York Mellon, London.
Paragraphs.
Yes, Lordship. Well, because I still remember after just joining Lordship, after I have joined the profession Lordship, I started arguing a case before Justice Gyani. And it's a tender matter, Lordship of GMC. Then he said, yes, it is allotted. I said, yes, my lord, it's given to. He has thrown the. He said, no, Mr. Sharma, dismiss. I said, no, my lord, I'll show something, Lordship. Give me 5 minutes. No, I'll give you 5 hours, no problem. But you have to satisfy me. And I started arguing, Lordship. That judgment is reported in 1996 to GLR. And I still remember in the last paragraph he said that filing of an affidavit is not a mere formality. It is the fountainhead of the whole judicial system. Looking at the affidavit of the GMC, he has given me the year, Lordship. He said, what type of affidavit is this? You have not denied, you have not said what you have, why you have taken this decision, no justification, nothing. Only said in the public interest. They took a year that it is in the public interest, Lordship. And in my case, Lordship, it's a very common line that I am running for last 7 years, last 10 years. Yes, I'll continue for 50 years if I am a L1, Lordship. If there is no hanky-panky, I'll continue for 50 years. Why 7 years? There is a tender process. I got the work. I am continuing. What is your problem? Always the argument is he is continuing for last 7 years, 8 years, 10 years. That is not the criteria, Lordship. Dear.
Noted.
Paragraph, Lordship, 18. At page 205.
Yes.
Litigation before our court are decided on the basis of pleading and evidence which are supported by affidavit. A proper and valid affidavit is thus the foundation of the case superstructure which is adjudicated upon by the court. If the affidavit is found to be defective, or if the affidavit suffers from some basic fundamental mistake, it is bound to affect the case superstructure. Affidavits play a vital role in the dispensation of justice and cannot be taken lightly. Filing of affidavit is not an empty formality. Since the outcome of the case depends on it, due to care and attention is to be given to filing in an affidavit. Then relying on some judgment, Lordship, para 34.
Yes.
At page 213.
Yes.
A comparison of the two affidavits prima facie shows
You want water?
at page 213, para 34.
Para
34.
34.
Page 213, my lord. Down below.
Yes.
A comparison of the two affidavit prima facie shows that those who have typed copies of some draft while keeping a date of signing of the affidavit blank, it was typed as, and I signed this affidavit on so and so date and so and so date. In the first affidavit, why I am showing this, Lordship, this part, even government, Lordship, in a notification, if the dates are not there, I have never seen, Lordship, this type of notification from the government, Lordship. All these notification, Lordship, even their government of Assam notification, Lordship, always, it is the date is on the top. They never keep it blank, Lordship. In the first affidavit, 24 was inserted by hand, whereas in the second affidavit, 4 was inserted by hand. After striking off the September, replacing it with the October by hand. The affidavit and all these things, all this problem in the affidavit was referred to in para 34, Lordship. So then the court says such glaring contradiction and the grossly careless manner in which the affidavit has been filed cannot simply be explained and brushed aside as mere typographical error. This is not a procedural error or a minor technicality which can be rectified by giving a further chance to the respondent to file a further affidavit.
35 to the.
This is in the context of a defective affidavit.
Defective affidavit, Lordship, in my case,
Context.
Lordship, the content, but the filing of an affidavit is not a mere formality, Lordship.
That is all right. That there is no dispute to that proposition.
Then,
Unexplained contradiction to what are the para 35 last 5 lines.
because Lordship, this is an affidavit in opposition. If the affidavit in opposition, it is unexplained and it is not contradicted,
It's all right.
then Lordship, para 35 last 4 lines.
The affidavit.
Yes.
Last 5 lines, Lordship.
Yes.
Para 30. The affidavit signed and affirmed on so and so date has not been filed in the court supporting the winding up petition. Respondent petitioner has not owned up the affidavit and glaring contradiction which are visible on the face of the affidavit and discussed above have remained unexplained.
Mr. Sharma,
Lordship.
coincidentally, I was assisting the senior counsel.
Lordship, in this case, Lordship, yes.
Suddenly I remembered now.
Yes, Lordship.
When you
Yes,
were
Lordship.
reading this paragraph,
Learned
suddenly
senior Mr. DK,
so
Mr.
this was a different
Yes, Lordship.
context.
I know.
This was a absolute.
No, context is different.
Because
Lordship, because it's a company petition, Lordship, winding up.
Not only that, not just that, because if I recollect, the affidavit was signed in Bombay, everything was blank in the affidavit. And that affidavit was served upon the respondent. So when the copy in the court's copy, it was obviously filled up subsequently. So a lot of things were there. And the identification was done at Guwahati, where the affidavit was signed at Calcutta or Bombay somewhere.
Yes, Lord.
I
So
forgot
winding
it
up
now.
and winding up.
You see, that's what, there is no proposition otherwise.
Yes.
You are right when you say the affidavit has to be candid and clear.
Yes.
There is no
But-
difficulty in that proposition. You don't need any authority for that. But I am only saying that as far as this case is concerned, the context is a little different.
Because this 96-2 GLR, what I had said, Lordship,
Yes.
that is where the court was. No, 96-2 GLR is 473.
Page?
Page 473.
No, no, it's 11 page.
Oh, I am reading, Lordship. I know. Lordship, may please come to page 480. For that purpose only, I am not relying
Yes,
on
yes.
for any other purpose this case, Lordship. Before partying, there is yet another aspect of the matter which requires to be dealt with. It is an affidavit in opposition shown by the deponent commissioner, Guwahati Municipal Corporation. A palpably false statement regarding the publication of bylaw in the official gazette, as already quoted above, has been made in the affidavit shown and filed on so and so. Filing of an affidavit is not a mere formality, empty formality. The administration of justice depends on oath. It is the fountainhead and its sanctity and seniority must be preserved. No one can be allowed to pollute the sanctity of the oath, lest to interfere with the smooth administration of justice. I am here only, Lordship. For no other purpose, Lordship, the way the affidavit in opposition is filed against the writ petition, Lordship, where a specific statement is made in paragraph 15, where you have denied, and now you said, yes, we have opened. In our record, it is there. How? Why you have not stated that in your affidavit in reply to the paragraph 15? You should have said that. Yes, you are correct. We have opened it. Why you have suppressed that? Now, Lordship, the point is, these things are there. The tender re-tender, tender, then lordship opening of the financial bid, all the. The question of law is now, lordship, can you make this JAM mandatory? On that also, lordship, I have to satisfy lordship
Yes,
that
yes.
problem. Suddenly, lordship, they said, now we'll go for JAM. For that, lordship, I have to go, I have to show your lordship a detailed affidavit filed by my client. That is at page 113, lordship.
That's pretty well.
Oh, even better, no?
113
13.
additional affidavit.
Yes, because when they filed their affidavit, lordship, that they will go for JAM, and it's a mandatory thing, lordship, nowadays.
Yes.
Then I got all these documents from page 121 onward on oath, lordship. I said that these things after this notification is going on. I specifically made statement in my affidavit that these are the department. I have given the detail. Lordship can see the detail.
No reply to all this.
No, my lord, no. Para 5 at page 115. Lordship get it. Para 5, page 115. That is subsequent to filing of the affidavit in opposition by respondent number 4.
1 second. Para 3. What is para 3?
Para 3, lordship.
Oh, so this is the
That
factual
is
part.
respondent number 4 in the said affidavit. That it is the factual statement, lordship. What they have said in their affidavit, lordship.
All
I have
right.
reiterated.
Then para.
Then para 5.
Yes.
That subsequent to filing of the affidavit in opposition by respondent, the petitioner has come across the collected some e-procurement tender and tender notice and tender document invited through e-procurement system government of Assam, which are as follows. This is a list A, B, C, D, E, F, G, H, I, J, K.
Hmm.
All these I have annexed. And lordship here, A is family welfare department, health and family welfare. B is health and family welfare. C, home department. Then D, health and family. E, health and family. F, health and family. Then this is medical college. Z is medical college. Assam Medical College itself. Then H, health and family. I, health and family. J, health and family. K, health and family. All these are not through JAM. And all these tenders are after that notification also. What they have annexed in the affidavit. And Lordship is pertinently asked a question, any reply? No. Lordship, that the different department can not do different thing. I'm showing the decision because while I'm arguing, Lordship,
Yes, yes.
on the affidavit point I have shown, Lordship. Now
Yes,
on
yes.
this point, Lordship,
You connect.
I want to show. Because otherwise, again, at the time of showing the judgment, Lordship, I have to take Lordship to those pages, Lordship, again.
Yeah, no, but-
Lordship, 2005, 6 SCC, page 292. 2005, 6 SCC, page 292.
2005.
5, 6 SCC,
Sorry.
page 292.
Rupa.
That Bhadilal chemical, Lordship. I'll directly go to page 23 because this is, fact is different and here. And I'll just go to the proposition, Lordship.
Para.
Para 23,
Page 2.
page 299.
This is for what?
This is that the government, there are different departments.
Same
They cannot take
department
different stand, Lordship.
cannot take contrary stand.
Same voice. Department to speak.
Hmm?
Government employee speaking.
So this judgment Supreme Court says the government department speak in the same voice, Lordship,
Yes,
and not may, Lordship, is should. Supreme Court says should.
yes.
Para 23, page 299. May I read, Lord?
Yes, please.
Slowly. There is another reason why the action of DCCT cannot be upheld. The primary fact relating to the process of undertaken by the appellant as units were known to the Department of Industry and Commerce and DCCT. The only question was what was the proper conclusion to be drawn from this. The Department of Industries and Commerce, which was responsible for the issuance of 1993 GO, accepted the appellant as an eligible industry for the benefit. Apart from the fact that it can be assumed that the Department of Industry was in the best position to construe its own order, we can also assume that in forming the scheme and granting eligibility to the appellant, all the department of the state government involved in the process had been duly consulted. The state, which is represented by the department, can only speak with one voice. This is my point, Lordship. This is my point, Lordship.
Dietary article to read content.
Yes.
So, Lordship, may please come to for a moment in my additional affidavit, Lordship, page 124.
Gemod available line, right? Mode idea.
124.
Yes. Because on that day, Lordship, while I'm arguing this case, my learned friend take a stand that the what document I have annexed to this affidavit, these things are not available in the GEM.
Hmm,
So they can.
hmm.
And my thing, the dietary service is available in GEM. So we should go for GEM. Now, Lordship, page 124.
Hmm.
Lordship, you can see the date on the
Hmm.
top, 25th March 2024.
25.
Four.
320.
25 March 2024.
Yes.
It is the Home Department Prison, Lordship. In the top, Lordship, organization.
Where?
In the top left side, basic detail. Basic detail,
Yes, yes,
Lordship.
yes.
Home Department. Then I'll skip, Lordship, all this valuation and all that's are there. Then in the fourth column, Lordship, work item, Lordship, get it.
Yes.
Title, supply of dietary article under zone 1 jail so and so for 24-2020.
This is which tender?
For jail, dietary
For
tender.
jail dietary article.
For jail.
Jail.
No, but,
Why I am showing, Lordship?
Huh.
This is also dietary supply. My Assam Medical College.
Here they have not,
No, it is not gem.
not gem.
Not gem. That's what I'm showing, Lordship. So the Lordship, the different department is speaking different word, Lordship. That's my point, Lordship. The same government, same service, same work, and this is the amount is higher, Lordship. It's a big amount, Lordship.
Where is the amount?
Lordship, I cannot show that, Lordship, because the 5,20,000 is there, Lordship. EMD and all that. And so it is a big amount, Lordship. The amount is not shown.
All right.
But when I talk to the client, he said it's a
All
big,
right.
big,
Anything
big
is not-
tender. Even
But it is
my
not
client,
here, so
my
anyway.
client cannot participate there.
Yes, next.
It's a big tender for, because the Lordship knows nowadays the prisoners are more than the hospital here, Lordship. It is.
All right.
Now, Lordship, about the question of law, that can you make this GEM mandatory, Lordship? Now, Lordship, this book, Lordship,
There you go.
If we have them, it's a funny.
Yes,
Section 28. Well, definition. Okay.
Lordship, let me start with the page 3, Lordship.
page
Lordship,
3.
Lordship, before I start, Lordship, is waiting, Lordship.
Can you be defined? No, it's all right. You.
Page 3, Lordship.
Yes.
3. It shall come into force on such date as the state government may by notification in the official gazette appoint, provided that different date may be appointed for different provisions of the act and may reference in any such provision to the commencement of the act shall be construed as a reference to the coming into force of the provision.
ৰূপক এইখন ৰূপক এই কিতাপখন অনাই লোৱা জি আছে Yes.
So this is my learned friend from the affidavit, he will satisfy your lordship. I will not go because this is the book. My learned friend has said this is mandatory, so he will satisfy your lordship that from the affidavit that there is notification or
This
the.
act shall apply to all procuring entities referred to in subsection 2.
Yes,
For the purposes of this act, procuring entity means any department of the state government or its attached or subordinate office.
yes. So that is there, lordship. Then the next page is,
Sub-rule 3, subsection 3.
yes,
By notification permit the to carry out permanent financial and assessment. And so, before decision. I am just, Mr. Sharma, what exactly you wanted to show from section 3?
no, I said that, see, first of all, it should go to the official gazette. And for whatever section, if my learned friend is bring a office memorandum and said that this office memorandum is binding on here. But this act said that if you want to apply something, then you have to, gazette notification should be there. It is to be.
2Q to the.
Where do I get that?
No, I'll come to that, lordship. I started.
This
No.
This is the act.
Oh, no, see, I'll come to that. Here, your lordship will not get it. I'll come to that, lordship. That is why I want to next. Come to the page 5.
Page 5.
Q.
Page 5.
Page 5.
Yes.
Q.
Yes, notification.
Means a notification published in the official gazette.
Okay.
So whatever be published in the official gazette is the notification, lordship, for this purpose, for the purpose of this
But
act.
that is, for this purpose, you mean subsection 3.
For the purpose of the acting rule.
No, for the purpose of the act and the rule. The whole act and the rule, lordship, this is the definition clause, lordship. So any notification under this, lordship, have
Has
to
to
be.
be official.
Yes, yes.
The term
The
notified.
state government may by notification
by
permit the
reference.
procuring entities to carry out procurement financed under the assistance from the multilateral banks. Very slow, with the procurement.
Term notify, lordship, you have to read with this notification clause, lordship. Lordship, in the subsequent, when I read this different section, lordship,
All right.
lordship will get notify, word
Okay.
notify.
All right,
There, lordship, you have to read with this, lordship.
okay.
That is why.
28. Okay.
So, lordship, at page 21.
Open competitive. Then
It is the method for procurement.
Page 21.
Yes, page 21, section 28.
Yes.
That the subject to, Lordship will take note of this subject to, Lordship, I will argue on that.
Subject.
Wherever is subject to is there, Lordship, I'll show a Supreme Court
Yes.
decision on that also, subject to. These are all subject to.
Yes.
The subject to the provisions of this act and the rule made thereunder, the procuring entity may procure subject matter procurement of this following method. There are different lordship. The red contract at the government e-market lordship.
Huh? Rate contract. Yes.
Red contract and government e-market, GM. Lordship get it.
Yes.
29.
Then
Yeah.
2, government may by notification, Lordship get it. Wherever Lordship will get this, that by notification, that is why that I have shown Lordship in the section 2Q.
Yes.
Now Lordship may please come to this.
Very important section. Easy Hindi Korea.
The state government may by notification declare adoption of electronic procurement as compulsory.
Electronic procurement.
Lordship get it.
তুমি কি compulsory করবে পারিবে না?
What does the word government GM means what?
Section
Government
36.
e-market.
Section
Is it defined?
It is section 36, Lordship.
All right.
I'll go to that, Lordship, before Lordship, if I can.
We'll go to that. Let's finish 2.
It is a defined thing, Lordship.
It's defined.
We'll get it. The state government may, by notification, declare adoption of electronic procurement as compulsory for different states and type of procurement, and on such declaration, every requirement for written communication under this act shall be deemed to have been satisfied if it were done by electronic means. Otherwise also, our is e-auction Lordship. 1, 2, 3, all retender. It is not the box dropping thing, Lordship. And in the even the e-market thing and the both the website is same.
Yes.
Electronic procurement is defined 2G. 2G. বেলেগ বস্তু হয় জেম বেলেগ বস্তু 2G to the করে section 2G. Electronic procurement is the same for
Yes. Where is that 30 section?
Lordship, before I go to that, Lordship has asked me what is e-procurement.
That is right.
That is Lordship at page 4, Lordship. Page 4. Page 4,
Yes.
G. E-procurement means the electronic process wherein the physical tendering activities is carried out.
Hmm?
E-procurement, G, Lordship, page 4.
This is electronic procurement. Electronic procurement.
Lordship, get it?
Yes, yes.
28(2) pertains to this.
It's an electronic process.
Yes, what I am reading, Lordship, now, this 28(2) is this.
Hmm.
What I am reading, Lordship, is 28(2) at page 21.
That is why you are saying it has to be officially gazetted.
Yes.
E-procurement ওটা বেলেগ কথা মানে আমার তো e-procurement এর লাইন
Where we have participated, that is electronic procurement.
now see what is gen section 30.
Yes.
That is electronic procurement. E-procurement. It is through electronic process, Lordship. I cannot drop in the box and
And that there is a notification gazetted.
তো পড়িব পারে
Now they are saying it has to be government.
it is jam.
e-procurement, GEM.
Yes, there I'll go, Lordship.
So what does government e-procurement means?
36(2).
It is 36(2), Lordship, at page 27. I want to go slow, Lordship, because this is new
Yes,
subject
yes,
for
yes,
me
yes.
also.
You want
27.
36. Before 36, you wanted to show something else?
Yes,
Section
Lordship, there's,
29.
it is, I one by one, then Lordship also
Listen,
will get the things.
go by your flow. I don't want to disturb.
At
your
page
flow.
21, Lordship,
21.
1. 28, I have read these two, Lordship.
Page 21.
Page 21, section 28, I'm there.
Yes, yes. Two,
The state government may by notification declare adoption of electronic possession.
that you've read.
Yes, then the next page, page 22.
This is the main section.
And Lordship, this is the main section.
Yes.
Open competitive bidding. Every procuring entity shall prefer the open competitive bidding as the most preferred method of procurement to be followed. 2. Open competitive bidding may also be followed in the case of two-stage bidding, like ours, Lordship, technical bid, financial bid. In terms of section 32, electronic reverse auction in terms of section 33, rat contract in terms of section 36.
Not rate contract.
Lordship will take note of this. This is,
Yes.
it is referred to, it is subject to all this. These things are subject to Lordship.
Yes.
The procuring entity may follow the pre-qualification procedures in so and so. 4. Where the procuring entity chooses a method of procurement other than the open competitive bidding, it shall record the reason and circumstances thereof.
Suspicion lies with procuring it.
We are reading where?
I am reading page 22,
Open mark.
page 22, open competitive bidding.
Yes, yes. Okay.
9(4).
I am
Open-
reading
Yes, yes.
2,
Subsection
3 and 4.
Yes.
Now I am reading 4.
Yes.
Where the procuring entity chooses a method of procurement other than the open competitive bidding, it shall record the reason and circumstances thereof.
Suspicion is with procuring it. State cannot come and impose that you now have only do this.
So now Lordship will read this sentence with the procuring entity. In my tender, procuring entity is the chief superintendent and
R4.
R4. He is the procuring entity.
AMC.
Now, the finance department or someone else sitting somewhere else cannot dictate that do this. If you cannot dictate this jail, why are you selecting this Assam Medical College? What is your interest? This is an open thing. If it is for the state, all the state government department have to follow. And why the first tender, re-tender, third re-tender, then you come to know. And this is an act of 2017, Lordship. After 8 years, now by office memorandum, you are teaching these people when someone is lowest in the tender. No, this is one thing is there, you can do this to cancel his tender.
And these are the committee people.
Yes.
These are the committee people. And yet the committee has recommended. And all of them are doctor. Ophthalmology, now they will decide e-procurement and all this. Leaving aside their daily patient Lordship, treatment and all.
These products are dietary products.
Dietary products.
Discretion भी आता कोट है state.
This 29 has not given the discretion to make GEM mandatory.
The state. Government is nobody.
Because for this Section 29, government is nobody.
Yeah.
Here, everywhere, Lordship, even the 5, in case of an open competitive bidding, the procuring entity, again, shall invite bid. I'm sorry, Lordship.
I just wanted to see what procuring entity, this is section 3 you had referred, right?
Yes,
Definition of procuring entity.
yes.
Section
Means any department of the state government or its attached or subordinate office. Any state public sector enterprise owned and controlled by the state government, any entity established or constituted by the constituent, so an entity or board or corporation, any other entity, any procurement support agency or procurement agent or procurement consultant involved in procurement on behalf of the procuring entity.
three, section 3.
You will, this R4 will be, I think it is
It
A.
is D, I
Huh?
think.
3(2)(d).
3, section,
3(2)(d).
Mr. Gogoi, here it will be A or D,
Either one.
according to you.
in section 3, the application.
Well, here it will be A.
A, right?
Of
Department.
any department of the state government or its attached or subordinate offices. Under health department, the office of the superintendent, medical college, automatically will be
No,
subordinate.
even I was thinking that
But
could
if
be,
you
but
look
I
at
just
it,
wanted
there
to
is-
know. All right, all right.
Section 3, application, well, very,
All right,
He
yeah.
is correct, man. My learned friend is correct.
and this is an act of the state, my lord, not of the central that will adopt.
All right, you will get your chance.
AMC.
So in my case, Lordship, the procuring entity is AMCs. There is no doubt about it.
Is
Procuring entity is AMCs.
Assam Medical
Assam
College.
Medical College. Now, Lordship, may please come to section
But in that
36.
case, it will be the health department.
Government will be health, other health department.
Health. Okay,
Department is not.
All right.
procuring anything.
Departments are not procuring entity.
section?
Section 36 is 27.
Yes.
State contract. State contract is included in open competition. Maybe.
Because here, Lordship, the 36 is started with red contract. So red contract is included
Open competition.
because after all, it's an open competitive bidding. Open competitive bidding, it's a red contract is there. Then and red contract and government e-market, GEM, both.
Section 2.
Yes.
This is.
It
not
is
open
the-
competitive.
One is red contract, my lord. Red contract is one, a procuring entity, again procuring entity, may choose to engage in a red contract procedure in accordance with the rule as may be made in this behalf under the Act, where it determines that the need for subject matter of procurement is expected to arise to an indefinite or prepared basis during a given period of time. Repeated basis, Lordship. By virtue of the nature of the subject matter of the procurement, the need for it may arise during the given period of time.
So, them to put.
Then, Lordship, the 2, government e-market, GEM.
Yes.
Director General of Supply and Disposal, DSND, host an online
Mr. Sharma,
government
I have-
e-market.
I have taken the liberty to mark your
Yes,
book.
yes.
Oh, yes, Lordship.
For the school.
Yes,
Yes.
I keep it for the court only, Lordship, sir.
Hmm.
Director General of Supply and Disposal, DSND, hosts an online government e-marketplace, GEM, on pilot basis. It's not even complete, Lordship. It's a pilot basis, Lordship, they have started, Lordship. Now they are taking risk in an hospital That too is the dietary thing, Lordship. There is a saying in Ye Lordship, Osin Kathot Pura Mara, in Ohomia Lordship, it is like that only. For common use goods and service, the electronic and online procurement process on GEM is end-to-end from placement of supply order to payment to supplier. It a B, Lordship B.
Hmm.
This is very important, Lordship. B is the Lordship. Government procuring entities, including the state government entities. Here, Lordship will get the difference. There are entities. It is not the government. There are different entities. Procuring entities, there are different.
Sometimes it could be the consultant
Yes.
in a given.
Yes, my lord. At their option, now Lordship may take this. At their option, may, and not shall. The egg is given that it is shall, it is may, Lordship. ZEM is not mandatory.
Yes.
ZEM is not mandatory, my lord. That is what my case, Lordship. Government procuring entities, including the state government entities, at their option may. আছে তার অংশটো?
Hmm?
No, no.
Any
He
confusion?
said that he wants to give his copy to him. I said, no, he had a copy.
Huh? Mr. Gogoi, you want this book?
No, I have-
You have it?
He has been.
Because the office has got one now.
No, no, it's all right.
You have it.
Yes. Government procuring entities, including state government entities, at their option, may
Hmm.
view, compare, and directly purchase online the product and service offered by various suppliers on GEM under
but
such
It's
conditions.
a discretion. It is not a mandatory.
It's a discussion. The whole year is given that it is mandatory. It is not. It is not. That is why all other
Now, suppose
tenders.
the government decides and makes it mandatory.
Let
This
them
code in
decide.
226.
Sometime, Lordship, they
No,
will
no.
decide. But
No,
this is not the time, Lordship. Now, Lordship, what is ZEM, Lordship? ZEM product is to be registered first.
Is a registered?
It's a registered product, like Lordship. Now we are bringing the thing from the Amazon, their Lordship will go for a watch. Watch Lordship will get so many watch from the Swiss watch, watch, various product. From there, Lordship will take one. They will give the price. They will give some also that you will get this deduction from for the Durga Puja, Bihu, all these things are there. So it is a jam. There is a Lordship. I'll give that
I
to your
think that
Lordship.
will also be required to understand what is.
Yes. That Lordship I'll
So
give.
it is like.
I have given a copy to your Lordship. Lordship file, it is there. On that day I have given. If it is there, Lordship, because when the matter was come before the Lordship can take one more. If Lordship is not getting it. Hey, এখন দি দিয়া।
One second. It may be there. Ek minute, Guru. I think I have seen something like that. Where do you get? Yes.
This is the central government guideline.
So this is the central government guideline, Lordship. Here the Lordship will think, Lordship will get everything, but the presentation, how to say, Lordship, it is, so it is page 33, Lordship. Bottom in the downline, there's a black line, Lordship. Page 33,
Yes.
5.2.2.
Applicability.
Yes.
Yes.
So this only Lordship, they now government has come slowly that how they will start, how they will do, all these things Lordship will get in this. Yeah. It is not even started, not even done, nothing. Now Lordship, like earlier Lordship knows in the PWD department, there are contractor, B grade, A grade, A, all these contractor have to register there here. Now contractor have to register in the JAM also.
If they want to.
Huh? Like it. Yeah. Now JAM registration is again required for the JAM work.
That cannot be insisted upon according to this.
Because at this stage, Lordship, if the government will insist in this type of thing, no. In a contract of October 2023, Lordship, in a tender.
It has no power under the legislation to say that.
Yes.
Because this act is very clear on that, Lordship. That is why I am reading this, Lordship, at page 28.
May.
May.
See,
May. Then, Lordship, I am reading this C, page 28. I completed B. I am reading C.
Yes.
The procedure and details of procurement through JAM shall be such as may be prescribed by the government.
prescribed is defined in 2R.
So this prescribed is defined in 2R.
Page 2, page 5.
Page 5, Lordship.
Page 5, yes.
Page 5 after Q.
Yes, yes.
Prescribed means prescribed by rules made under this act.
If they are rule making power.
Now, Lordship, may please come to page 50, section 55. At page 34.
Page 34.
34.
Yes.
The provisions of the. Then mandatory.
56.
55.
55, Lordship,
Yes.
55.
Powers of state government to make rules.
Yes.
Hmm.
Now, reading the first line, Lordship. 1.
May.
The state government may, by notification, again, make rules for carrying out the provisions. To carry out the provisions, Lordship. Now, Lordship, by a office memorandum, you cannot go beyond this, Lordship.
Go beyond section 36, section 29.
By office memorandum, you cannot bypass the section 36, 34, you cannot bypass by an office memorandum. The procedure is prescribed. Then it is subject to these, that, everything is subject to. Then, what is the wisdom? Wisdom is to carry
Out the
out the procedure.
provisions of the act.
Yes.
The state government may by notification make rules for carrying out the provisions of this act, and different set of rules may be made for different classes or categories of pronouncement or procuring entities. Even this is not complete law. Rules are there. Procuring and rules are not there. Only Assam public procurement rules are there.
Yeah, those are the procurement rules. They are prescribed.
No, it is not there. Even in the rule, it is not specific that it is mandatory. They have not said. It is not specific. Then 2, in particular and without prejudice to the generality of the foregoing power, such rule may provide for all or any of the following matters, namely.
19.
Then Roman 19, at page 35.
Yes.
Procedure in respect of the various method of procurement under section 28. That I have read, Lordship, already.
Roman 9.
19.
Roman 19, Lordship.
Procedure in respect of various methods of procurement under section
Determine
28.
the
Under
procedure.
section 28,
So this has to
section
be
28,
prescribed
Lordship,
by
I have read.
notification.
the method of procurement and all that,
Proposed
Lordship.
There has to be rules.
Yes.
For procedure.
For determining the procedure for.
Yes,
25 to 1.
right.
Then, Lordship,
Roman 25.
recognize the next page today as Roman 25. Now, Lordship, Roman 25 at page 36.
Yes,
Any other matter which is required to be prescribed by the state government for carrying out the provisions of this act. So, it is 25 is very clear. Now, Lordship, the 56.
yes.
These are all subject to, started with, power to issue guideline, 1, subject to the provisions of this act and the rules made thereunder, a procuring entity may issue guidelines giving details of procedure or general norm or standard specification and manual required for giving effect to the provision of this act and the rules made thereunder. Hmm?
For giving effect to the provision.
Then 2.
No, no.
Na lage.
There was
Now, Lordship,
section
Huh?
58, there is only one provision under which they can make gem method. And that is
100.
page 58. To be the rules. To the para 58. Section 58.
Then the page 36 itself, Lordship, down below, power to exempt is also there.
Yes,
If the state government is satisfied that it is necessary in the public interest so to do, it may, by order published in the official gazette, or for reason to be recorded, in such order, exempt any procurement or a class of category of procurement or a class or category of procuring entities from application of all or any of the provisions of this act. It is
Official
also-
gazette. So then
But the everywhere, Lordship, it is official gazette, Lordship. Notification is also defined. So in any notification will not do. If any notification will come, it will be gazetted.
you have to
Alright.
what reasons for making gem mandatory under it.
So the saying in the affidavit that it is a mandatory now in view of that office memorandum is not correct, Lordship.
This memorandum will also be reasons.
now assuming you have a legal point. This court finds that yes, your submissions, you've made a legal point. Would that be sufficient for this court to
No.
cancel the?
Then
letter?
Lordship no. Then Lordship see the conduct, arbitrariness, malafide,
What have you pleaded?
everything. My writ petition malafide and here it is.
Where, which paragraphs?
Yes, Lordship.
There's a prayer to page 22.
आगे तुम कुछ मेला में जैसे ही लोग होते थे उड़वा ना
23 OS.
Huh?
Right? Para 23 page 90.
Lordship is started at page 16, para 18.
Yes, I have 16, para 18.
Page 16, para 18, that the
Yes.
petitioner begs to state that the respondent authorities with malafide intention did not open and evaluate the financial bid of the petitioner and the performer respondent to accommodate some vested interest person for extraneous reason. The decision of the tender committee has been influenced by political interference and favoritism without there being any application of mine. It is pertinent to mention herein that the petitioner is not only experienced in providing dietary service. But also there is an allegation made from any quarter against the petitioner during the last 15 years of his death. In fact, the petitioner is continuing to provide dietary supply at a very low rate in spite of the inflation under the mass financial hardship, considering the interest of the patient. In spite of the repeated request of the representation that the students in the review the rate. The petitioner begged to state that as per the illustrative checkpoint, various stages of public procurement, that single tender party, then Melaphaidi is many a place,
Para
Lordship.
23 to
Para 23, Lordship. Page 19. Para 22 is the, Lordship, this article 14, 19 and 21. Para 22. In para 23 is specific, Lordship. That petitioner begged to submit that the respondent authorities cannot exercise their power arbitrarily, irrationally, but must depend for its validity on the existence of congruent reason for such action. The power to be exercised in coupled with duty. In the instant case, the respondent authorities has abused, exceeded their power for extraneous reason. The impugn action of the respondent authority is not transparent, and the same has been done with a Melaphaidi intention, oblique motive, and political influence. It is well settled that whenever the procedure of the state proposed to follow in the matter of tender process must be transparent and at par with the other similarly situated person, as such the arbitrary, irrational, unreasonable, high-handed Melaphaidi action of the respondent authority is liable to be examined by the Honorable.
Yes.
Then, Lordship, the all other thing, my paragraph at page 22, my prayer.
B.
B. Page 22. Mandamus should not be issued directing the respondent authority, more particularly the respondent number 2, 3, 4, and 5, to award the contract of the dietary service to MCH Dibrugarh pursuant to the e-tender dated so-and-so, after evaluating financial bid and the petitioner and performer respondent number 7. So this is
Specifically, I
my.
have made it in my prayer. It is Saisa.
So I do not know. Paragraph 15, I made an oath. I came to know that you have opened. So I have taken a risk of this prayer B.
All right.
But there is no denial, Lordship, as of date. Now the document is very clear.
Self the coordination in zone 1 and that itself is Melaphaidi.
Then, Lordship, in the Act, Lordship, it is very clear at page 20.
Yes.
And there is no affidavit also to develop this, Lordship. Page 20. The decision of the procuring entity,
26 year.
it is section 26(3).
Yes.
Page 20, 26(3). The decision of the procuring authority to cancel the procurement and reason for such decision shall be immediately communicated to all bidders.
This is
That
not
parties,
done.
No,
It has not
No.
been communicated.
No.
to you?
and it's a Lordship now, it's an online thing. Any communication, it has to be uploaded, Lordship. Now no one can say, no, I have given on such and such date.
It's not available in the
No,
portals.
no, my lord.
cancel to
And there is nothing in the affidavit, Lordship. And what is the cancellation by respondent number 4? It is recommended.
All right. Now, as regards the first tender, second tender also there was
No.
never,
No, never.
never intimated.
No,
And the third also not.
no.
Have you made this statement also otherwise?
Yes. I make one year yesterday. I know Lordship when the matter was listed before this court. I said, show me that line that where we have stated that
Yes.
they have not yet. It is
Para 5, page 9.
para 5, Lordship.
Of your writ petition.
Yes. Page 9,
Yes, I have paraphrased.
Last 3 lines.
last 3 lines. The
In
technical
technical
bid
bid,
only of the
only the
petitioner is
petitioner
qualified by the
qualified.
financial bid of the petitioner not open without assigning any reason. One, Lordship. Then,
That it was cancelled.
then page 10. Page 10.
Yes.
Last 5 lines.
Para 6, last 3 line,
5.
5 line.
Yes.
In the said tender process, 4 bidders, including the petitioner and performance participated. In the bid document concerning the technical bid of clause 14 was inserted, whereas in the next technical bid format, no such requirement was mentioned. In that view of the matter, the technical bid of all the bidders were rejected. It was not informed. Then Lordship, please come to page 13. I have marked this. I know Lordship will ask this.
Yes.
Last line. It is pertinent to mention herein that the said minus dated so and so was uploaded in the website in so and so, but all other subsequent thing was not uploaded except this.
Yeah. Para 13.
Because why I have said this specifically, Lordship, what is uploaded? Lordship, take note of this. Para 11, last line. Lordship, get it?
Yes, I've taken-
Then para 13, last line.
Prior to that, nothing has been uploaded regarding financial bid evaluation in the website.
Gem they straight away uploaded without cancelling.
All right. Resume at 2.
Lordship.
Yes. All right. Have you take, both side is there?
In the morning, you are there, but I have finished.
You are for the appellant?
Mine.
Your name?
There.
Dale Oscar. Next week at a date. Yes.
Right.
Yes, Mr. Savarna?
Item number 9, minus, yeah, the part hard matter minus. So.
Yes.
Technically,
Huh?
may not teach also today.
When do you want?
Maybe might have after tomorrow or next.
Tuesday? 9. Yes.
So last come first, Lordship, before raising Lordship has put me a question, Lordship, whether to this act and rule. In fact, my case has nothing to do with the act and rule. I have not, while filing the writ petition, there is nothing. But why I have to argue when they file the counter affidavit, Lordship, there they said that there is an office memorandum and that office memorandum has referred to that act. So that is why I have to go there. Otherwise, I have nothing to that. So, to cut short the thing, Lordship, I am in a tender process, Lordship.
Hmm?
I am in a tender process. I joined in a tender. Tender process, you have to decide the tender, who is the lowest tenderer, and you have to.
Fairness has to be seen.
Yes. So if Lordship is there, then even my learned friend can show this, even always the petitioner said, the Tata Cellular has said all the Lordship is 1994 6 SCC 651.
Decision-making process.
Yes. So in the process, Lordship, what happened and what the authority will see. So in the para 77, Lordship, at page,
Because here you have demonstrated before this court that this decision of till now, you have demonstrated before this court that the decision for not accepting you as of now appears to be of the committee,
yes.
which was a recommendation sent to the procuring authority.
Yes.
That perhaps since there is only two
Yes.
persons
So that
may not be
I am there,
accepted.
Lordship, because when
GEM.
the affidavit
And
is not
GEM.
clear, there is no point.
And that in fact, this is the third time,
Yes, third.
the same tender.
And it is they have
This
written.
time there was about three, I think 4 participants.
Yes.
Second time about 2 or 3.
Yes.
And now 2.
Too valid, but to valid tender, Lordship.
Valid tender. Participants are more.
Participants of valid tender too. In the earlier Lordship 4,
No, in the present third retender,
participant 2 and
participants.
both of them are valid.
Yes, para 70.
At page 677, Lordship, para 77.
Yes.
Because in a very narrow campus, Lordship, the it's a tender matter, Lordship. The duty of the court is to confine itself to the question of the legality. Its concern should be whether the decision-making authority exceeded its power, committed an error of law, committed a breach of rule of natural justice, reached a decision which is no reasonable tribunal would have reached for, abused its power, then it is only concerned with the manner in which those decision has been taken. I am there. I am what I am on, my lord. It is only I am concerned with the manner in which those decisions have been taken.
Yes.
The extent of the duty to the act fairly will vary from case to case. It's a fact of the case, Lordship, because there are many decision, Lordship. There are several decisions on the tender matter, Poddar and all these. Somewhere it is said that the government is the authority, government will decide. It is the government tender, government can decide. Shortly put, the grounds upon which the administrative action is subject to control by judicial review can be classified as under. 1. Illegality. Here I am on, Lordship. Illegality. This means the decision maker must understand correctly the law that regulates its decision making power and must give effect to it.
Law is section.
If you sense the rule after the game is started, that's not the decision making process, Lordship. You cannot do that.
How can you make your own law beyond the act?
Now, by office memorandum, you cannot go beyond the act, beyond the rule, frame under the act. That you cannot do by an office memorandum. So, these are their, Lordship, the Tata Selva, Lordship knows at the cost of repetition, I read it, Lordship. Lordship, now, Lordship, may please come to the book at page 83.
He went through the purpose. In the system.
Because in the office memorandum, this is the rule they have referred to.
Which rule?
Rule 24.
Rule 24, Lordship, at page 83. In the office memorandum, they have referred to this rule.
Page 43.
No, 83.
80.
Method of procurement and procedures thereof.
Is made under section 55.
Yes.
219.
So I have shown that 55, section 55, Roman
Yes.
19, Lordship. I'll skip the first three lines. I'll read. A procuring entity may choose different method of procurement specified in subsection 1 of section 28 of the Act if deemed more advantageous and appropriate after recording the specific reason and circumstances in writing for so choosing in exception to the preferred method, that is open competitive bidding method in terms of the subsection 4 of section 29 of the Act. So they have to give some reason, Lordship, which is lacking. The document, what they have produced before the court, there is nothing. In the affidavit, they have not said so.
They changed the rule.
You sense the rule of the game now.
They're legislating by an office member.
That too by an office memorandum.
Page 100.
My lord, that these three lines at the cost of repetition I am reading
Yes,
because,
please.
Lordship, because they have referred to this only.
Yes, please.
A procuring entity may choose different method of procurement specified in subsection 1 of section 28 of the Act if deemed more advantageous and appropriate after recording the specific reason and circumstances in writing for so choosing in exception to the preferred method, that is open competitive bidding method in terms of subsection 4 of section 29 of the Act. They have make it rule, it should have been exception, Lordship. They have make it a rule now in
Yes.
case of exception.
Yes.
Such specific reason and circumstances shall be recorded in the case file. I am on. What I am on, Lordship, from the day one.
Where are the reasons?
Nothing. Nothing, Lordship. At least from the procuring agency. The person who have attended the meeting, they have recommended it. Now, after recommendation, what? It is, the affidavit is silent, the document is silent.
Page 100.
Such specific reason and circumstances shall be recorded in the case file and clearly noted in the pronouncement register, procurement register, indicating the name and designation of the procurement entity making the decision. And Lordship, I do not know. For some reason, Lordship, the JAM tender record is not there. In the affidavit, nothing is given. So, where the reason will come? Where you have finished, that I have finished this part and I will start now, the next thing. Both is required, Lordship. Here you have to give a reason that I am finishing this method. And why? That these are the reasons. This is also not there. So you have referred to a
Records will
rule.
have to be checked
Yes. Yes.
because ultimately whether the decision-making process has been transparent, fair or not,
Yeah.
that only the records will.
Yes, the record will prevail. And that will prevail, Lordship. If it
The
is
official
silent.
position is that including this, on 3 occasions, they have cancelled the tender.
And if it is not there in the
Because
record,
without cancelling, you can't retender.
no.
Now, if you have not cancelled and you have gone for a retender, then it is obvious it is a continuation.
And you cannot select that what you will upload, what you will not upload. It is an open, transparent thing. Whatever decision you have to upload. And then affidavit is silent. Even if, for a moment, let us presume that the affidavit they have said all these things. That also they cannot do because of Mahendra Singh Gill. By filing affidavit, they cannot.
That's why I said
Develop.
records will speak. Where
So record
records
will
have to
speak.
be seen.
The record will speak the volume, Lordship. What is the EA, Lordship?
Page 100.
So now, Lordship, may please come to page 100.
This is the relevant rule.
And this is the relevant rule, Lordship, finally.
11.
Page 100, Lordship. Left hand side, Lordship.
Yes.
Government e-market place, that is JAM. 1. Procuring entities may, Lordship. Procuring entities may, as appropriate in public need and interest, utilize the government e-marketplace JAM facility for the purchase of their essential common use need determined as available therein, subject to the provisions of the Act, the guideline that may be notified. Why I am saying, Lordship, it is subject to, then notified. In this regard, by the state government and without exception, the condition that the rates for the items offered by the supplier, the JAM, or the total cost involved thereof are not higher than the prevailing wholesale market price in the state or the discounted rate of the authorized dealer in the state or the applicable sale. Then, Lordship, I'll skip 2. Lordship may please come to 3, Roman 3. Because 2 has nothing to do with my case, Lordship.
Yeah.
All such procurement through them shall be subject to, again, subject to the prior sanction of the concerned compounding authority with reference to the relevant delegation of financial power rules in respect of the subject matter and the value of the procurement. All these things are missing, my lord. The saying is not there. Like in injunction lawsuit, we said that for granting an injunction, you have to have the prima facie case, balance of convenience, irreparable loss with the public interest. Now, there is a saying. The whole saying you have to, yeah. Now here it is very specific. But there is a missing link, lordship, everywhere.
Yes.
Therefore, the government in the finance department, now here, lordship, the state government in finance department shall notify that Q2Q. I read, lordship.
Official
It
gazette.
should be gazette.
Detailed guideline.
Yes. The detailed guideline for such online procurement through them together with, it should have been with, lordship, with the mode and procedure for making payment to the registered suppliers thereof, and maybe also prescribe financial selling or any other condition for the purpose.
কিন্তু বিশেষত ম্যান্ডেটরি করে দেবো না আমার
So-
প্রসিজার প্রেসক্রাইব করে দেবো
This has not given a year that the exam is mandatory.
কার্ড প্ল্যান শেয়ার না এটা
In this case, lordship, this is not a proper case to say, lordship, all this. But why I am showing, lordship, because they have referred to 24. So I have to place it. In a proper case, lordship, where we'll challenge all this, then, lordship, we can take all this point. Otherwise, this is not a fit case, lordship, because in my writ petition, these pleadings are not there. This has come, lordship, because of the affidavit filed by the.
দিস শোজ দ্যাট ইলিগালি
No, I'm coming there.
নট রাইট
So my friend is saying we are not saying for striking now. I know, lordship, that is not my argument, lordship. I say, lordship, because they have referred in the office memorandum, this rule 24 and all this. So this is the thing they have to complete. Then only, lordship, not haphazardly, lordship.
Noted.
legality of the office memorandum has to be considered.
So that way, lordship, legality of the office memorandum has to be considered, lordship, under this laws. That is my humble submission, lordship.
All right.
Only few
Which
small
one is that?
judgment.
Which one is that?
Lordship, it is 1964 Supreme Court 207. It is South India Corporation Private Limited, lordship. Para 19, lordship.
What I have
If lordship can take a copy of the constitution, lordship, because then it will be helpful.
Constitution
lordship.
also.
Then it will be helpful, lordship, because of this paragraph, lordship, otherwise not.
Let's see the paragraph.
Oh, that is only one. 1964 Supreme Court, page 207.
Para 19.
Para 19, lordship.
Yes, please.
Page 215.
Yes.
That apart, even if Article 372 continues the pre-constitutional law of taxation, the provision is expressly made subject to the other provision of the Constitution.
So you are
The expression.
You are stressing on the expression subject.
Subject. Because the whole act, all the provisions, all the rule, everywhere, lordship, will get this word subject to. So
even-
my only here is for this decision is that it is subject to, lordship. Lordship.
So, are you
Because
trying to say that the other sections are also independently, they can operate. They are, that is what are you
Yes,
trying to
yes,
say?
yes.
Subject
For
to
that
means
purpose.
that
It's
it is not
subject to mean that.
exclusive.
sir.
This rule is subject to the provisions of the Act.
Everywhere in the rule, it is said that
Subject to the provision of the rules.
yes,
The Act.
So that means what?
it
It
is
means
subject to the provision of the Act clause.
act.
Section 29 and 36. have the-
Then it is 29, 28, all that is subject to, this rule is subject to all those. 36, whatever I place before a lordship. The rule everywhere is subject to.
Just complete that paragraph of the
Yes.
apex court judgment.
Yes, lordship. That effort, if the Article 372 continues the pre-constitutional law of taxation, that provisions is expressly made subject to the other provisions of the Constitution. The expression subject to conveys the idea of a provision yielding place to another provision or other provision to which it is made subject. Further, Article 278 opens out with the non-essential clause the phrase notwithstanding anything in the Constitution is equivalent to saying that in spite of the other article of the Constitution or that the other articles shall not be an independent to the operation of the Article 278.
Non-authentic clause.
So that is 278 is non-essential
Correct.
clause, that is what. So this 372 is subject to lawsuit. So what is subject to and what is the effect of the word subject to
Yes.
is the decision lawsuit.
There are 40.
I know my learned friend will show all the decisions of the tender matter lawsuit. So
Tender decisions can be cited from both sides.
you
You never know which way it will click.
so yes. So and I know Buddha is he's on that
Yes.
lawsuit is very clear. 2006 11 SCC is 731.
Now, as per the tender decision is concerned, give me one or two. Don't.
Yes, that
If you multiply.
no,
the
no, no.
authorities, you
These
will
are
be
not tender. No,
delaying
no. I'm
judgment.
not on the tender decision. I leave it to my learned friend. I know my learned
Because,
friend will show the
otherwise
power of the court and all that.
scope of Article 226 in tender matters.
I
Yes.
don't. I have not
I don't
taken
think
that.
we need any authorities
lord.
for that.
I'll
Tata
not-
Cellular is the Bible. You have given it.
Yes, yes.
This is on.
And if required, one can look into South Kerry, DFO South
Yeah,
Kerry.
so
Soma.
DFO South Cape, then
and also-
many others.
Yes.
And last but not the least, there are some decisions from this High Court also. So nicely written. There is a judgment of Arup Goswami, the Honorable Justice Arup Goswami, my lord. Very small, precise, but referring to all. My lord, this 2006 11 SCC page 71, paragraph 44. I am reading at page 753, lordship.
Placetum B.
Recitum D.
B. B.
B.
1 second. 7.
753.
Yes.
Placetum B. Placetum.
Yes.
Line about 5 from the top, lordship. When
Yes.
the Act and the statutory rules have not prescribed any definite term
Precedent
any-
B.
B.
listen, just above the precedent B, lordship. It is the line about 5
Yes,
from
yes,
the
I've
top.
see- yes, yes, I've got. When the act and the statute.
Yes. When the Act and the statutory rules have not prescribed any definite term and any particular mode, the High Court could not have read into the statute a restriction or prohibition that is not expressly prohibited by the Act and the rule. It is well settled that when the statute does not lay down the method of appointment or terms of appointment, and when the Act specifies that the appointment is one of sure tenure, the appointing authority who has the power to appoint has absolute discretion in the matter, and it cannot be said that discretion to appoint does not include the power to appoint on contractual basis. Then 45.
Power to lose.
So here in this case, lordship, by an office memorandum, this power was curtailed. So the para 45, lordship. It started with the word office memorandum. The official memorandum dated so and so on a plain reading of the applies only to the government servant. It has no matter of application to the employees of the servant of statutory board. The appellant is not a retired government servant. His appointment as managing director of the board is not a post of the government service. The High Court has erred in law in applying the said official memorandum to the appointment of the appellant, which is governed only by the act and the rule. Even otherwise, now here I am on laws. Even otherwise, the High Court has failed to appreciate that the official memorandum running counter to the statutory provision is ineffective at any event, cannot be enforced by a quo warranto proceeding.
In our case also, there is an office.
So this is regarding office memorandum lawsuit. Whether by that office memorandum lawsuit, what they have annexed to the affidavit in opposition, lawsuit, the statute, the act and the rule can be bypassed or the
Prayers in the eye.
Yes.
so with this lawsuit, the my learned friend said no, tender decision with him. So I in reply, if
Yes,
necessary,
sir. Try to reply.
if reply lawsuit.
Gautam,
So this is so this is my humble submission before Lordship, and my prayers are very simple, Lordship. If Lordship, the record shows that my financial bid is open and I'm a lowest bidder, it is because the Lordship, the third DA is very crucial, Lordship. What the document is given, they himself they have written in the minutes. In the last one, it is very specific, Lordship. When they have opened at page 9 of that bunch, I'll read, Lordship, no, to take the. After scrutiny, all the bidders, as stated above, were found to be technically qualified. As the tender was called for third time, the committee members have decided to open the financial bid on 2024. So it is they himself has said that we are the committee member. We are not the authority.
and can you just read once again the other where they have said that
Yes, I'm reading that, page 11.
Yes, yes.
Since there were only 2 bidders participating in the process, to have a better participation and involvement of more numbers of bidders to ensure the quality, the committee members would like to recommend.
This is something very strange because in first they said third time, so let us open. You open,
Exactly.
and then you say that just because there were 2 and for better quality now let's.
And from the day one, every time,
It is even anyway suggested that because it is you're not getting a good rate, we need a good rate. I could have understood. If that was
Too complicated.
prevalent in the mind of the
And Lordship
committee
will keep in
members.
mind, this is an open bidding, this process. ZEM is a restricted bidding. Brother, where will they get the competitor then?
That is why it's malified.
And when you have started the process of registering and all
I
that,
think after the arguments are over, both sides, a small written
Yes.
note would be.
I'll try my best. Lordship.
Mr. Gautam, you
Yes, yes.
can prepare
We will do.
a small written
So,
submission.
this is
Yes,
my,
very well.
Yes.
yes, my friend is there.
Yeah. Over, Mr. Sam Sharma, you're. over.
Yes, yes.
Yes, Mr. Gogoi.
My lord, here, Lordship may kindly turn to page 33. It has already been placed, my lord. This is the first tender was issued. And it
30.
was cancelled, page 33. E1023.
Yes,
This was the first tender that was issued. Connecting to the present issue, my lord.
yes,
And it was cancelled.
yes. Where is
After
that
the tender,
cancellation?
well, yes, cancellation, my lord, that once. Yeah, in the court record.
আৰু বাইণ্ডাৰ্ছ ক্লিপ দিব
এখানে অ্যাশ শর্মা petitioner বলি দেখুন একেলগে কৰি দিয়ক হয় আছে Yes. 11.
Yes, sir.
Yes.
26, 10, 23, my lord, that minor. So that,
22. This branch you are referring to.
yes, the first page.
Yeah.
It says, my lord, first tender, my lord.
AC2 confusion. Yes.
So, my lord, here, the tender was open. And finally, only one bidder was found to be, my lord, well,
Hmm?
so you will see in the second phase,
Hmm?
3 bidders, my lord, have participated,
Hmm?
and one was found to be well.
The committee evaluated the tender.
Ranjit Verma is the petitioner. Axis
Okay,
contractors
3.
and
After
Axis
detail,
and-
so there is only one valid bidder. So the committee has decided to suggest
Yes, sir.
for retendering. Tender inviting authority and add the following points.
So these are the new points that we are doing incorporated in the second
Yes.
bid, retender.
Yes, then.
That lordship will find at page 35. It is 9-1,
Page.
page 35 of the petition.
Yes. You have to correlate this with your decisions.
Yes, then also we see the bunch.
Yes, because you see, 35 is a third tender.
One thing made clear, so far as the first tender is concerned, it was cancelled, there is no challenge to that. Petitioner again participated.
You see,
Just to explain to the court, but there is no challenge to that.
Mr. Gogoi, irrespective of there is a challenge or not challenge,
Right.
the issue here is as regards the decision-making process.
Fine.
And this entire thing starts from the first tender.
I-
Now, when this court has to examine the
Yes.
decision-making process, this
Not-
court cannot just confine
I'm
its
just saying,
finding
well,
to the
so far as-
third tender only. The
Because
court
there
has
they
to
will
look
challenge if they
everything.
Participated, the petitioner participated.
They may have. You see, this court is not on all that right now,
Lordship,
correct?
lordship.
An illegality has been demonstrated in a manner now, whether that is illegality is there, not there, this has to be ultimately decided by the court.
Lordship.
Now, how do this court decide? Only when you give me the record,
Yes.
you indicate
Yes.
that everything at every stage has been transparent and fair.
Mine,
If that is so, end of the matter.
mine.
Correct. You are the tendering authority. It's your prerogative. You want to retender it as many times you want. That is your, but you must have reasons for doing it, and those reasons has to be reasonable.
Lordship,
Correct?
mine. So in the first tender, my lord,
Yes.
there were 3 bidders, only one was found to be well, so it was cancelled. In the
No,
second. bid-
but that was the committee. The committee have said. Now, where is the decision of the procurement agent? Procuring authority, cancelling it.
My lord, moment the fresh tender is issued, automatically it transpires that, my lord, there is a decision, my lord.
No, but then you are bound by these rules,
Yes, yes.
correct?
Or if you apply it to all, all permanent.
My lords is perhaps looking for section 26.
Correct. 26,
That's at
correct?
page 20,
Page?
20 minutes, section 26(3).
The decision of the procuring entity to cancel the procurement and reasons for such decision shall be immediately communicated to all bidders that participated in the procurement process. You see, your record, because what I'm trying to tell you here is, yes, the committee have said that for this reasons, and they say recommended. Now, once that reaches to the procuring authority,
My lord,
a decision has to be taken, correct?
yes.
That yes, we are cancelling it. These things has to be shown in from the record. Only by issuing a retender notice, second retender notice is not going to sufficiently discharge that burden because everything has to be seen now. Anyway, as of now, you have you are
So for the first first tender cancellation is concerned, the minus I have placed.
Hmm.
Now, second lordship will find at page 4. The second tender.
Page 4 of this compilation.
Of this, my lord, company.
Yes.
Lordship will see here, my lord, 4 bidders were found. They participated.
Hmm.
The committee of, after scrutinizing their documents, found that, my lord, all 4 bidders are not, my lord, qualified.
Are not qualified.
Not qualified. All bidders, last line of the first para, hence the committee has rejected all the bidders and did not open the financial bid of the bidders. And this was not put to challenge.
Then the third.
Now comes the third, which is the, my lord, subject matter of the present petition. Here, my lord, on 12 to 24, as has been placed by the other side.
You
the
please ask your junior to flag mark all this from the records. Huh?
lordship.
This must be available in the record.
Yeah, it is there, my lord.
And the note sheet is there.
My lord, this is a tender committee's record. There won't be any note sheet, my lord. There will be.
Where will be
But
the
because
note?
whatever decision is taken is taken by the committees.
By the committee.
Yes, by the
But
committee. Minus should be there.
committee is not the procuring authority.
The procuring authority, my lord, ultimately it is the principal cum chief superintendent under whose
R
authority.
four.
Yes, R4, under whose authority, my lord, this entire process was being.
There are no other records you mean to say,
My lord,
besides the committee
but-
records. Is that your summation?
No, my lord, so far as this particular tender process is concerned of the committee, that record I have, minutes and all, it's there.
Where is that?
Yes.
So, no, but
I
Mr.
will
Mr.
check my-
Gogoi,
For convenience.
let me
my lord,
understand you correctly.
lordship,
According to you, these records that you are
of the
holding
tender committee,
is of the tender committee.
Not a responder for direct.
Correct. So
Official.
respond number, that is why my
So
immediate,
that record, of course, my lord, it's not available with me. my
then you
lord, but
have
Yes,
to
yes.
place that as well,
My lord.
because that will
Subject
indicate.
to the recommendation. made
Yes,
by
because
decision
you
or
see,
record-
committee is not the procuring authority. Let us be clear on that.
My lord, my lord.
Yes,
So, my lord, this is the minutes of the technical committee.
yes.
Page 6, it starts of the third tender. It was cancelled and, my lord, it's challenged before it is on number 4.
Found 2 numbers of bidders were participating, scrutinized so and so.
That's
Then-
page 9, my lord. After scrutiny, all the bidders as stated above were
Technically
found
qualified.
technically qualified as the tender was called for third time. The committee members have decided to open the financial bid on 22/2024
Yes,
at 2 p.m.
yes.
So, my lord, this is the date fixed for, my lord, opening of the financial
Yes.
bid. Page 11, my lord, the minus of the financial bid is there.
Yes. Since there were only 2 bidders
Yes,
participating,
also you will see, my lord, there.
to have a better participation and
points, my lord.
involvement.
Yes, for better participation as well as.
No, but that better participation, this committee people didn't know on this date, on 12/2/2024.
but
They,
the-
they didn't know that.
Whatever
they
is there.
know-
I
Mr.
understand
Gogoi,
what-
on 12 February 2024, before opening the financial bid, they were aware that there are just 2 participants.
My lord,
But they said that this is because this is the third time we have done retender. Therefore, we have decided to open the financial bid. Now, what happened in the meantime that suddenly now they have decided ki no, no, no. They changed their mind. No, no, we need better participation.
that is what there in the minus. I
So,
can
so
say
you
this.
see, Mr. Gogoi, this is not inspiring the confidence of the court.
My-
This is where
there I
this
need
is
to-
where you need to
Yes.
back up. You have to show what is there in the records, what happened.
No,
Because this
whatever
is the
there in the
decision-making
minus-
process, correct?
There, my lord, only the minus.
Yes.
This my lord, there is no notice. At least of the committee one.
No, but the committee only, have you understood what I am saying?
I understand.
I could have understood after opening, they are saying, ki, no, no, these rates that have come is not,
Inspiring and all.
correct,
Too low.
correct. But they are talking about participation. Is that something which they didn't know on 12th of February when the technical bid was
Yes, so far This
scrutinized?
point is concerned, my lord, it is clear from my lord first technical bid also.
And because, all right, you have shown that there were valid reasons as per the first tender cancellation and second is concerned. Because second, there was no valid tenders
No,
only.
yeah. So, my lord, this is the ground, my lord. I cannot go beyond this, neither, my lord, can be modified.
Yes, that
So this
is
there,
where
black and white.
the now entire thing will It's 10, right, Mr.
Yes.
Gogoi?
Now, my lord, the jam part comes, my lord, in the next page 12, my lord. Would like to recommend the principal so and so to float a fresh tender through jam portal. Earlier. it was
And you
about
see,
the
they're
portal.
talking about to ensure the quality.
My lord.
The committee members would like to recommend. Now, the principal come chief superintendent and superintendent AMCH is not a postmaster, isn't it? He is the authority.
My lord.
He has to make a decision.
Lord,
The committee may have recommended,
my lord.
but what were before him for making a decision that no, we'll go for a retender. We will not accept the lowest tender.
My lord.
We will not accept the offer of the selected lowest tender. Where are those materials? You have to place that before the court. Have you understood, Mr. Gogoi?
So far as my lord.
This court is mindful of the limited jurisdiction that this court exercises in matters of
Yeah.
contractual
Right.
tender. But nonetheless, this court can always go into all this. This is what the court has to do in such matters, right?
And
Examine the decision-making process.
Article 14
and-
will have to be looked in, but.
Correct? Fairness. It has to. So you have to satisfy the court
Well,
that
but-
there were materials, there were something for the procuring authority R4, because his affidavit doesn't talk about anything. His affidavit is very casual, Mr.
Let me
Gogoi.
say, my lord, may I say that?
Yes, yes.
Lordship may kindly turn to the affidavit because minute is. my lord, it's clear
Yes,
by-
yes, minute is
that
clear.
part. Lordship will see para 4 again, my lord, page
Yeah.
99,
Para
4. Page 99.
of the affidavit of
Four
R4.
and 4, yes.
Yes,
Para 4, my lord, the second para.
yes.
The important part is to submit that only 2 bidders participated after the third bidding. In the first tender bid, 3 bidders participated. However, in the second time, 4 bidders participated. And the third time, 2 bidders participated. Further, the government by its office memorandum dated so and so made it mandatory for them for all procuring entities for procurement of all goods and services that are available in them.
Here he doesn't even mention that the tender financial bid was open, the
Right.
committee has recommended. Nothing is mentioned. You see, it's a very, this court is,
Para 11.
this
now.
court is
Yes.
expressing its displeasure in the manner the affidavit has been filed, Mr. Gogoi.
My lord, we
Very
cannot,
casual.
but we cannot write anything beyond the record.
No.
It will have to be supported by the record.
Mr.
The minor
Gogoi,
before it is on the
Mr.
court.
Gogoi, is it a fact or not that the financial bid was open?
Yes,
it
that
is
I
a
have-
fact.
Yes, I have. the
Correct.
same instruction.
Now, you see, these minutes, these facts is not part of this affidavit. R4, if R4's affidavit, it should have been, there should have been some clarity of the facts, right?
But-
He should have averred that the financial bid was open, but after opening, the committee was of the opinion and recommended so and so. And then what did he do?
My lord,
This is what should have been there in the affidavit.
my lord.
But look at paragraph 4.
The 11 lord may see, my lord. But otherwise, my lord, it is repetition of same, my lord. Para 11 also.
Yes,
It says, my lord, only 2 bidders qualified, but them is mandatory and participation of more bidders.
it
is
doesn't
required.
talk about his decision. He is the person who has to take a call. It doesn't talk about anything.
My lord,
Simply because the committee recommended, and that also he doesn't say. In the affidavit, he doesn't say that.
that, my lord, record I will try to place, my lord. I will place it,
Tomorrow, day after tomorrow, Thursday.
but Thursday, day after tomorrow. Then I-
Yes, I will forget otherwise.
Yes, yes.
You see, I don't want to keep this matter unnecessarily. You both agreed that the
Yes, yes,
matter
yes.
can be disposed of
No,
on
no, I
that
will place
basis.
record by any means by the Thursday.
Despite there being a lot of hearing
Except-
matters on board today, I had taken it up because you both
No, we
said
have urgency. my
That's
lord.
right.
my lord, yes.
these matters are
Yes.
definitely larger public interest are involved. That is the only reason I had taken it up. So Thursday and
Except 29th any day, Lordship, 29th
You have some difficulty.
Except 29th.
The 30th, my lord.
that's
Only on
Friday.
that fine, yes. Only I will
Friday.
place the record.
Yes, Friday. Heard in
Well,
part.
otherwise, my lord, this is the ground stated in the affidavit.
Give me again. Heard Mr. S. Sharma, learned senior counsel, assisted by Mr. A. Gautam, learned counsel for the petitioner. Also heard Mr. um, B. Gogoi, learned additional, you're appearing as an additional advocate general, learned additional advocate general for the state respondent. Um, Both sides having consented for taking up the writ petition for final disposal. This matter was taken, this matter was heard. However, the hearing could not be completed. List again on Friday, such and such date for further hearing. On that date, Mr. Mr. Gogoi shall also have the relevant records as relating to the decision of the respondent number 4 for retendering the subject tender for the third time in connection with.
Fix at 2 lordship, then lordship can finish up the other matters at 2 o'clock,
All right, all right.
2 p.m.
Okay, Mr. Sharma. I'm keeping your book.
Yes,
Very
lordship.
well, because I have apparently
Lordship has marked it. No, no.
marked it
Yes, yes.
Interim to continue.
Interim to continue.
interim order, if any, shall continue to the next date of. Mr. Gogoi, please have it, huh? That information. And this record which you have brought today is of the committee
Of the committee, but these are minutes is there, others.
that you retain.
I will retain.
You retain it, right?
Only for respondent force record on the decision making process, I will place. If there is any, otherwise.
Yes, if any. You cannot make now, neither can this court force you to produce something which is not there.
Lordship.
If it is there, you give it. You can let it go.
Grateful, Lord.
Yes. Why is this for orders?
May it please the Lord. My lord, in the second appeal, my lord, I am the appellant. And in these 3 IAs, I am the applicant. My lord, the subject is for substitution of respondent number. This is respondent number 16.
Or the IAs are for substitution.
Substitution.
3 IAs are for
So
substitution.
1 for substitution, 1
One for,
condonation.
which is condonation.
Condonation is 1086.
How many days? Delay?
It's 6.
That's 6. 197, 197.
196.
1086.
1086. And substitution is 2582. Which is the substitution?
1089.
1089 is substitution. What is 1088?
Abatement.
Abatement. And what is 2582?
2582.
You're not placing that
No,
today.
not placing.
Mr. Ghosh, you are appearing for the respondents. You have any objection to the condonation,
I have no,
substitution,
no, not.
abatement? তুমি বেলেগ বেলেগ কে ল'ব লাগিব, হা? এতিয়া মোক এটা এটাকে দিয়ক। First, give me 1086.
Only after passing of the order, my lord, only prayer is there. Prior to that, there was, the service was complete. If I have filed early hearing petition, that was the.
You want the second appeal to be heard on an early date?
Yes.
All right,
Then-
there's no difficulty, Mr. Ghosh. Heard Mr. KK Dey, learned counsel for the applicant. Also heard Mr. SK Ghosh, learned counsel for the respondents. You are, Mr. Ghosh, you are for?
Respondent number.
No. I know the quick থেকে আসলো জানি না আমি কিন্তু
After he finishes this item, change.
5, 6,
Mr. Ghosh for 5, 6?
6. Then
You do one thing, Mr. Ghosh.
I've seen-
Mr. Ghosh, please do one thing. In respect of the three IAs that I'm going to dispose, respectively, just put your appearances because there may be some change in your in the arrangement of the respondents. You just give it, both of you. Hit a side over, huh? This application is fine for condoning the delay of
Money.
1075.
My lord.
1075, right?
My lord.
1075. In filing application for setting aside the abatement and substitution of the legal heir of the deceased respondent stroke defendant number 16 in the accompanying regular second appeal.
Respondent number.
Deceased pro forma
Pro
respondent stroke pro forma defendant
forma.
number 16. The brief facts of the case is that during the pendency of the regular second appeal being RSA number 249 stroke 2017, the pro forma respondent stroke pro forma defendant number 16, i.e. Hirak Jyoti Chakraborty died on 2012-2021, leaving behind his legal heir. Stop. Accordingly, it necessitated substituting the legal heir of the said pro forma respondent defendant number 16. However, since the substitution application could not be preferred within the time frame, within the stipulated time, the appeal, the appeal stood abetted against the pro forma respondent defendant number 14. Correct? 16. Stop. There, accordingly, the application for setting aside the abatement and for substituting the legal heir of the pro forma respondent defendant number 16 is being filed. However, a delay of 1075 days have occurred, as hence the present condonation application. This is the correct facts, now, Mr. Ghosh? Abetted, isn't it? Because of not filing within the time frame.
Because actually they are not contested, they are not ex parte also, then no appeal has been preferred.
But whatever, but this is the factual aspect, isn't it? Huh. Mr. So-and-so, learned counsel for the petitioner, applicant submits that.
My lord, one correction, my lord, defendant number 90,
Not 16.
16, respondent number 60, but defendant number.
It was about respondent number 16 stroke defendant number 19. Huh? Submit that the abatement, setting aside of abatement, the application for setting aside of abatement and substitution could not be filed within the stipulated time period because of reasons beyond the control of the applicant. Stop. Mr. So-and-so and Mr. So-and-so submits that they have received no instructions to oppose the condonation. Right. Heard, perused. Apt to reproduce paragraph 3, 4, and 5. 5, 9. 3 and 4, huh? 5, 9, I don't think so. 3 and 4 of the Condonation Act. Reading of the aforesaid application, averments, it appears that the grounds averred are sufficient and bona fide. As such, the delay of 1075 days is condoned. Disposed of. Now, abatement 1088. Parties name can you save me? Brief facts of the case. Hetu he upor part to same thakibo. Oi dibo laibo niki? Oi diyo dia. Brief facts of the case is that during the pendency of regular second appeal number 249/2017, the pro forma respondent number 16 pro forma defendant number 90, I, Hilak Jyoti Chakraborty, died on 20/12/2021, leaving behind his legal heir. Stop. Though the legal heir ought to have been substituted in the place of so-and-so respondent, so-and-so defendant, as the right to sue survived. However, since the substitution application could not be filed within the time frame, the appeal stood abated against the said respondent stroke defendant. Hence, the present application for setting aside the said abatement is being filed. The grounds in support of the prayer made in the application reads as under para 3, 4. Okay? No, you, Mr. Counsel, you have this 1088 is not abatement. 1088 is also a condonation. See your prayer?
Actually, my lord, I am newly engaged.
Huh? Mr.
The
Ghosh, you have the
prayer is for abatement 1088.
Huh?
Prayer is for abatement.
Be pleased to set aside the abatement by condoning the delay of 1075. Huh? How?
By setting aside abatement.
But in that earlier condonation, do we have condoned?
Both prayer has been made.
Lordship may not go by this melody.
But in here also, if you see, I think there's a mistake in the prayer because 1086, the prayer is pleased to condone the delay of 1075 days by setting aside the abatement in so and so number of so and so for substituting of so and so.
Copy paste.
Huh?
Copy paste.
No, but I think there has to be two condonation applications. Huh? One is good.
One.
So hey, what and first with Monokuma for the delay of so and so for condoning the is condoned for filing the abatement or hey declare. Okay. That will be doing it. And in this, last কি করলো? Are sufficient cause for allowing the application for setting aside the abatement. So accordingly, the abatement, the automatic abatement of the appeal of the regular second appeal against the respondent stroke performer defendant stroke stands set aside. Disposed of. It's just substitute. Okay. That to me is same during the brief facts of the case is that during the pendency of the regular second appeal, RSA number 249 of 2017, the respondent defendant so and so name to Kuba died on 2012-2021, leaving behind his son, Himani Chakraborty, late Hirak Choti Chakraborty, resident of Hailakandi town, ward number 14, EO Lakshmi Sahar Chakraborty Para, district Hailakandi, Assam, PIN number, phone number, 507 up. He being the legal heir of so and so, the right to sue being survives. Accordingly, the present substitution application has been filed. Accordingly, no Popa. That being so, the instant application for substituting the legal heir of so and so respondent defendant in RSA number 24917 stands allowed. Accordingly, it is provided that is substituted in the place substituted in place of R60 allowed disposed of. Now, in the RSA, you say, in the substitution, I think an amended cost title has to be given. Let an amended cost title be furnished before the registry for doing the needful. You please give it. And in the RSA, you say list, when do you want it?
No, next week. Next week. Because some urgency because my
Chunar data detail, 4th, 5th, Silop, Thursday. List on 10/6/2025.
and 6.
Yes, 10 June.
May I please, the pair of both the parties, this matter may kindly some other day.
All right, as jointly prayed, sorry, wrong.
My lord, in this regard, I would like to confirm that there are two paper books in the record. I may be allowed to take one.
As jointly prayed, relist when?
As per your convenience, Lordship.
12 for 12.
Lordship, well,
It's a jail appeal.
yes, your Lordship.
No. Thursday?
But Lordship, just to add here, I mean, already the term of the imprisonment is over in this matter. So,
All
Lordship,
right, next week.
Yes, ma'am.
Next week or the date did you, and you take that instruction of this. Next week or date did you on such and such date.
fifth.
Obliged, your lordship.
Yes,
In this case, my lord, we have already filed our written argument. And as per order dated 29/11/2024, my lord, the hearing was already concluded. But this honorable court sought some instruction from the learned counsel for the education department that whether a cabinet proposal was subsequently made cabinet memorandum, and they have stated before this honorable court that they could not trace out the same. And thereafter, they have filed their compilation on last date, my lord. And accordingly, this case has been fixed for further hearing today.
we are not there today. Heard, Mr.
UK Das, my lord.
A.K. Das, learned counsel for the petitioner, none appears for the respondent on call. Relist next Tuesday. Tuesday
My lord.
for further hearing.
Lordship, my senior is in court number 17. Can the matter be passed over for the time being?
Not pass over time being now. All right, as prayed for by Mr.
S. Agarwal.
MS S. Agarwal, learned counsel for the appellant, which is not opposed by the MS.
M. Nath.
M. Nath, learned counsel for the caveator stroke respondent. Relist when?
Next week, Lordship.
What date did you? Fifth of June.
Obliged, Lordship.
Wait, please, your lordship. My senior is on leg in court number 14. So can the matter be taken up on some other day?
When do you want it?
Next week, any day, lordship.
Next week or बहुत हो गए नहीं? Next week or did you? It is 23. Is that 23 matter? So after 1 week then, as prayed for by MS.
S. Ajmi on behalf of R. Chaudhary.
As prayed for by M. Sorry, I
S.
didn't get-
Ajmi.
as Ajmi,
Yes,
learned
sir.
counsel appearing for the appellant, which is not opposed by the other side.
Lordship,
My lord, this matter supposedly, my lord, we had filed one IM, my lord, considering the urgency of this matter, case, my lord. So may I play not third of June, my lord.
Which is not opposed by the other side, relist on 3/5/3/6/2025.
Date the
25.
Date the honest.
नाम किधर ले लो?
Ah.
कोई कौन लेगी?